Hmm. Hmm.
Sober item 15.
Yes, Mr.
Another rare people also similar. There is intent. There is no intention to kill the wife. The PW1 is the PW2 is the test child test mallet. In her 161 statement, she has stated after seeing the Jatara while they are returning, the petition, the appellant was on see something where there he became angry and there was a quarrel and he picked up a stick, assaulted the wife mallet. There is no intention mallet for kill.
You want us to see the 161 statement? It's all like that. Can we utilize it?
So far the PW2 mallet childness in our cross exemption, here that there was a gondogolo mallet. There was a gondogolo between the wife and the husband mallet. The lots of PW2 the child witness mallet. My humble smell, there is no intention. If he has some intention mallet.
धीरे धीरे बजान दो. पूरी कौन कोई
cross exemption part से कहूची page paragraph 2 रो page 53
53
yes page 53 paragraph 2 cross exemption part से कहूची lots में
paragraph 3 not 2
paragraph 2 cross exemption first cross exemption.
That part is there in page 54, my lords. The very first.
Paragraph 3 I was like,
prior to the incident, there was.
Sometimes my mother went to her father's house after Gondola with my father. But that day, after returning from that.
See, I have also not told about the Gondogol between my father and mother to my grandfather and grandmother. It appears that there was a Gondogol. So he picked up a stick and assaulted. There is no intention. He has been assaulted. Said paragraph 253 page paragraph 2 re. May I read again, my lord? 8 to 10 days after the occurrence, I was examined by police. I was at Chohata in the house of my grandfather Oja while I was examined by the police. I went to the police of my grandfather Oja 3 to 4 days before my examination by police. My grandfather and grandmother had never tutored me to speak about the Gondogola between my father and mother. I have also not told about the Gondogola between my father and mother to my grandfather and grandmother. That I was emphasized, my lord, there is a Gondogola, my lord. Because, my lord, in her ancestor statement, your lordship yesterday read, my lord. They, after return from the Jatra, my lord, these appellant has, along with the daughter, my lord, they saw something, my lord. Whereas a Gondogola was appeared. Thereafter, he picked up a stick and assaulted. That's why I pray, my lord, that may be on a 304 part 1.
No, but suppose let us say some kind of disturbance took for which the appellant assaulted the deceased.
My lord.
But see subsequent conduct that
कंडक्ट मालर से जेतले माइला सी भाबिला से पड़ी जाई बोली के से चेता नाही
No, no.
तेनु से झियो को भी कहला पानी देना कि सेठी भी से कहि पथन तो मां मोरु पानी देना से ता मां को भी माइला वाले भी कहनी जे तते मु आज मार देई बोलिया
no, ପାଣି ମାନେ ଜଣେ ମାଡ଼ ଖାଇଛି ଏବଂ ସେ ପାଣି ଟିକେ ମାଗୁଛି and he is asking PW or preventing
yes
rather
but he can
PW
say that ये भी ता झियो कहि पन पानी देना से मां मरि जाऊ मार एई भले कंडक्ट बोले से कदा भी मरिया कथा से
how
कहू
one
नहीं
speak, that's a different matter.
से दैट्स व्हाई आई एम प्रेइंग माय लॉर्ड 30 part 1
Evidence has remained that you prevented
yes I have prevented to give water
to the child who he was asking for water,
my lord
and you denied the child or the wife to take some water. And not
Sorry.
only that, then you told that this was sleeping with injection, then secretly
that
taking
was
the
my lord
body.
exact version of the PDOL 2 my lord he has not stated before the IO जे स्लीपिंग इंजेक्शन दिया आइची कि बापा ता डेड बॉडी नै 2 दिन परे पोखरे पोतिले
No, but
माई हम
dead
समस्या
body was recovered at your instance.
yes at your instance my
part-
lord the
So,
PW3 my lord he has stated before in chief my lord he has stated the petitioner was led the police party along with in cross examination he has stated that he along with the other witness and the magistrate and the police was present but he never in cross examination he had not stated that the present appellant was present my lord and your lordship also seen the inquest report there was not mention in about the presence of the appellant at the spot my while the dead body was recovered. At best 304 part 1 your lordship 13 years is in remand ଗଣ୍ଡଗୋଳ ହେଇଥିଲା ସେଠି ଦେଖିଲା ପରେ ଗୋଟେ ଗଣ୍ଡଗୋଳ ହେଇଛି ଯାହା ଫଳରେ ସେ ବାଡିଟା ଉଠେଇକି ମାରି
how many years you were in custody?
my lord I was granted bail but after release 13 years 3 months as per the appellant version my lord 13 ବର୍ଷ 3 ମାସ ରହିଲା ପରେ this honorable granted as per lordship
You were taken into custody when?
my lord 7/6/2003 my lord
7/6?
2003 the date of release टा मो पर नाही
My date it High Court order ta hala 29/11/2013.
my lord
Then that was modified because he could not deposit that. There was a direction to deposit cash certificate of rupees 25,000.
my lord
That he could not furnish then, and that order was modified on 9/12/2014, and it was reduced to 15,000. So
7/6/2003 the date of arrest custody my lord 12 ବର୍ଷ
8/5/2015. ଏଠି ଲେଖା ହେଇଛି ବ୍ୟାଙ୍କ ଏଠି ଡିପୋଜିଟ୍ କରିବାକୁ 2 weeks ଯୋଉଟା ବି ସେ ଆରେଞ୍ଜ କଲା 2015 7/6/2003
3 was forwarded 6/6 was arrested 7/6/2003 was
ଏଟା ଦେଖି ଯୋଉ ଫାଇନାଲ ଫର୍ମ ଟା ଦିଅ ଟ୍ରାଏଲ କୋର୍ଟ ରେ
page 80 of the paper book IO has stated I forwarded the accused on 7/6/2003 page 80
ଫାଇନାଲ ଫର୍ମ ପାଇଁ ମନ ଇଚ୍ଛା କରୁଛନ୍ତି ଏସବୁ କାମ କିଛି ନାହିଁ ଗୁଡା ୟୁଜଲେସ୍ ଗୁଡା ପ୍ରଥମେ ଏଫଆଇଆର ରହିବା କଥା ତାପରେ ଫାଇନାଲ ଫର୍ମ ରହିବା କଥା ହଁ ତାପରେ ଚାର୍ଜ तापर एविडेंस कॉपी prosecution no तापर accused statement तापर defense witness हाँ serially करिकिन जेमती पेपर बुक रे रही है चार्ज शीट कॉपी दियो pending of charge sheet को दियो आनंद बड़ा चार्ज शीट आधेर मध्य लेखा है statement 27 statement which has been marked as exhibit 7 आज 6/6/2003 समय अपराह्न 3टा समय रे स्वेच्छारे बयान करियोछु जे एई टाइप रो घटना so the statement which has been given the time is 6/6/2003 अपराह्न 3टा so two statements are before us the evidence it is completely contrary to each other when that statement was made. Number one, when the statement was made is gote part. Where the statement was made, that is another thing. PW3 cannot be stayed to be a witness to leading to discovery. Since he has stated that after the statement was given, I came back home. Returned back home. He has not stated that I accompanied the police party to the place where the dead body was. So, number 4, inquest report accused instance re मिलिवा nahi. So, if we create doubt about the version of PW2 child witness, particularly on account of the delayed disclosure and chance of tutoring to such a witness, then giving exaggerated version in the court for the first time about that injection, father taking the dead body and burying it, which he has not stated. And this statement goes, then the only thing remains is the extrajudicial confession before two witnesses, PW4 and PW5. PW4 and 5 केबे कहउछंदी तांको extrajudicial confession हला. You come to the evidence of
I know the informant and the accused standing in the dock. I also know the deceased Chand Bibi. The deceased Chand Bibi is the wife of the accused. Chand Bibi expired 12 to 13 months back. One day the accused came to my tea stall situated near my beetle shop in the morning at 7:30 to 8 a.m. and he himself disclosed before us that he has killed his wife Chand Bibi and told that he is going to surrender before the police. Across, my lords. I have seen police came to Jaraka to the house of the accused along with him. It was about 9:30 a.m. when police and accused went towards his house. The tea stall where the accused narrated the incident is adjacent to my beetle shop. 10 to 12 persons present when the accused told about the incident before us. The accused was talking like a madman at that time. None of the people present there detained him from going to the police station. The police station is at a distance of half kilometer from my beetle shop. I was not examined by the police. It is not a fact that the accused did not confess before us.
Come to PW5.
Lordship. I know the informant and the accused standing in the dock. I also know the deceased Chand Bibi. Since died. I know the deceased Chand Bibi who has died since more than 1 year. Accused is the husband of Chand Bibi. One day at 7 a.m. in the morning, I was taking tea in a tea stall at Dharamsala market. The accused came there. I asked him why he had come so early in the morning. The accused replied that he has killed his wife Chand Bibi. The accused also took tea in the said tea stall. At that time, accused was residing at Jaraka market, opening a broiler farm along with his wife, Chand Bibi and children. I have stated these facts before the police. Cross your lordship. Accused came to the tea stall in between 7 to 7:30 a.m. and left the tea stall at about 8 a.m. He went to the PS. I cannot say if he returned back along with police. The said tea stall belongs to Sachikanta Mohanty. The
PW4.
PW4. The beetle shop of PW4 is in front of the tea stall intervened by the road. 4 to 5 persons were present when accused disclosed that he had killed his wife. The accused disclosed just in front of the tea stall where we were sitting on a bench. Myself and PW4 were present, but I cannot say the names of others present there as I did not know them. The Dharamsala PS is at a distance of half kilometer from my house. The tea stall where we were sitting is also at a distance of half kilometer from the PS. Prior to the date, I have not heard about missing of Chand Biwi. The house of PW3 is at a distance of 300 feet, intervened by 3 houses from my house. I was examined by police 5 to 6 days after the accused disclosed the fact before us. It is not a fact that I have not stated before the police that I was taking tea at tea stall at Dharamsala market, where the accused came and disclosed that he had killed his wife, and I asked him why he came so early in the morning. It is not a fact that I have not stated before the police that the accused also took tea and that the accused was staying at Jaraka market along with his wife and children. It is not a fact that the accused did not confess before us. It is not a fact that I am deposing falsehood at the instance of PW3 as he is my co-villager.
So the question is that why the accused would disclose or make extrajudicial confession, the reason of making extrajudicial confession. Because unless he expects some kind of help he will get from these two persons, or they are very closely acquainted with him, friendship ଅଛି ତାହେଲେ ଯାଇକିନି ଗୋଟେ voluntarily ତାଙ୍କୁ disclose କରିବ ନହେଲେ ସି ଯଦି ଜଣେ accused ଯଦି ଏତେ secrecy maintain କରୁଛି ଘଟଣା ପରେ ସେ ଚୁପଚାପ ନେଇ ଡେଡ୍ ବଡିକୁ ଲୁଚେଇ ଦଉଛି କେହି ଜାଣି ପାରୁନାହାନ୍ତି ତା ବାପା ବି ଜାଣି ପାରୁନି ଯଦିଓ ସେ 300-400 ଫୁଟରେ ରହୁଛି କେହି ଜାଣିନାହାନ୍ତି ସିଏ କଣ ପାଇଁ ଯାଇକିନି ଆଙ୍କୁ କହିବ ଯେ ମୁଁ ତାକୁ ମାରଲି ବୋଲି
Lord, sir, my submission is that he was having a guilty conscience at that point of time.
No, no.
Because the version of the witness is that he was confessing and he wanted to surrender before the police.
There is no evidence that he surrendered. Rather, he was arrested in Yarka market.
Yes, but that shows the mindset of the accused at that point of time.
ଯଦି ସେଇଆ ଆପଣ ଦେଖନ୍ତୁ ଯଦି ଏମାନଙ୍କୁ ସକାଳେ 7ଟା ବେଳେ ଆଙ୍କୁ କନଫେସନ କଲା
My lords.
ହେଲା
My lords.
ପୋଲିସ ଷ୍ଟେସନଟା ଦୂର କେତେ ବାଟ
Half kilometer.
ହାଫ କିଲୋମିଟର ତାହେଲେ ତ ଯାଇକିନି ପୋଲିସ ଷ୍ଟେସନରେ ପହଞ୍ଚି ଯାଇଥାନ୍ତା ସାଙ୍ଗେ ସାଙ୍ଗେ ନା ଯଦି ସେଇଆ ଆପଣଙ୍କର କେସ୍ ହଉଛି ତାହେଲେ 2ଟା ବେଳେ ଯାଇ କାହିଁ ସେ ମାର୍କେଟରେ କେମିତି ତାକୁ ପୋଲିସ ଆରେଷ୍ଟ କଲା ତେଣୁ ଦ୍ୟାଟ୍ ଏକ୍ସପ୍ଲାନେସନ ହ୍ୱିଚ୍ ହାଜ୍ ବିନ୍ ଗିଭେନ୍ ଦ୍ୟାଟ୍ ସେ ବୋଧେ ଗିଲ୍ଟି କନସାଇନ୍ସ ଥିଲା ସେଇଟା ସେ ରିପେଣ୍ଡ କରୁଥିଲା ଯାଇକିନି ପୋଲିସ ଷ୍ଟେସନକୁ ତେଣୁ ଆଙ୍କ ପାଖରେ କହି ଗଲା ଦ୍ୟାଟ୍ ଇଜ ନଟ୍ ଆକ୍ସେପ୍ଟେବୁଲ ୟୁଡ୍ ହାଭ୍ ଗନ୍ ଦେନ୍ ଆଣ୍ଡ ଦେୟାର ତାପରେ ଏମାନଙ୍କର ଯୋଉ କଣ୍ଡକ୍ଟ ଏଭଳି ଗୋଟେ ଜିନିଷ ଜାଣିଲେ ଜାଣିକିନି ସେମାନେ ଚୁପଚାପ ହେଇ ରହିଗଲେ ଦେ ଗେଭ୍ ଦେୟାର ଷ୍ଟେଟମେଣ୍ଟ ସେ କେତେ ଦିନ ପରେ କହୁଛନ୍ତି ଆମେ ଦେଲୁ ବୋଲି ଷ୍ଟେଟମେଣ୍ଟ 4 to 5 days କହୁନାହାନ୍ତି ଗୋଟେ କିଏ କହୁଛି ପରା
PW5 କହୁଛି
PW5 କୋଉଟା କହିଛି 4-5 ଦିନ ପରେ where is that line
I was examined by page 62.
I was examined
5 to 6 days after
So,
that, he disclosed the fact before us.
ବାପ ଘର ହଉଛି ପାଖରେ ଆକ୍ୟୁଜଡ ଏମିତି ଗୋଟେ କହିଲା ଇଏ ତ ଆଗେ ଯିବା କଥା ଥାନାକୁ କହିଦବା କଥା ତା ବାପାକୁ ଜଣେଇଦବା କଥା ଲୋକାଲିଟିର 300 ମିଟର ଦୂରରେ ବାପ ଘର ହାଫ କିଲୋମିଟର ଦୂରରେ ପୋଲିସ ଷ୍ଟେସନ ଆଙ୍କ ପାଖରେ ପୋଲିସ ଇଏ କନଫେସ କଲା ଇଏ ଚୁପଚାପ ଦେଇ ରହିଯାଉଛନ୍ତି 5 ଦିନ ପରେ so what sanctity can be attached to such statement how they can be accepted that they are truthful witness and they are not making out a case after 4 to 5 days to just create a circumstance again dita jinso first thing hochi there is no evidence of any closeness hala so one is absence of closeness with PW4 and PW5. Number 2, no reason why the appellant, who had maintained all secrecy, to disclose. Number 3, conduct of PW4 and 5 in not telling police or to PW3. Next, disclosing after 5 days. So these are the factors which create doubt about the extrajudicial confession part. Detection. That is why it is repeatedly told, when you argue a criminal matter, you take up a criminal case, go through the brief once again, because repeated, when you go into it repeatedly, you can get the clarity.
My lords.
And if you close the mind, then it would, because yesterday when the matter was placed, we find that it is a hopeless case. But today, the Learning Council started to make it somehow or other 304 part 1, and because he has already undergone about 12-year sentence. But again, after going through all these things, doubt cropped up in our mind that no, there is something, some missing link, and some witnesses have been picked up, all these things. So
Only one judgment I have.
yes, please.
Cited.
What is it, Judge?
Lords, on the evidentiary value of child witness, man. Because I would only like to conclude by revisiting the evidence of PW2, my lords.
Yes, which is the paragraph?
My lords, para 41, lordship, may take page number 7. Page number 7, the first line, my lords. May I place it, my lords?
Page 41.
Yes,
That
para
is
41, page number 7, my lords. At the very beginning.
that case has been referred to 2008, volume 39.
Lordship. Lordship has given observation on the next page, page 7.
Acha,
A child of tender age, the line starts like this.
40.
Page number 7, my lord, the very first line.
Yes.
41 paragraph contest.
That the continuance of para 41, my lord. Sir. A child of tender age can be allowed to testify if he has intellectual capacity to understand questions and give rational answers thereto. The decision on the question whether the child witness has sufficient intelligence primarily rests with the trial judge, who notices his manners, his apparent possession or lack of intelligence, and the said judge may resort to any examination which will tend to disclose his capacity and intelligence as well as his understanding of the obligation of an oath. The decision of the trial court may, however, be disturbed by the higher court if, from what is preserved in the records, it is clear that his conclusion was erroneous. This precaution is necessary.
This observation made by this court can be utilized against you, because yesterday the learned counsel for the petitioner made a submission
Lordship.
that the trial court ought to have recorded the questions put to PW2 before his examination chief. He ought to have recorded the questions put to him and her, and what was her answer. There is no scope on this court on our part to examine whether the decision taken by the trial court was correct or not.
But the trial court,
Simply a statement has been recorded
yes, that he has
I
examined
put some questions to the witness and found that she is answering rationally.
rationally, my lords.
We don't have any scope to examine whether his assessment was correct or incorrect.
Your
Because
Lordship,
it is not on record what were the questions put to her and what was her answer to those questions.
the Lordship can take the evidence for that purpose.
That is, you are right. That is one part.
My lords.
Because what my brother is trying to point out that the observation which has been made by the London trial court,
Lordship,
that is able to give rational answer, that is not the final.
Yes.
Okay.
Questions are not recorded.
So it cannot be said that whatever has been mentioned, that cannot be. That is why it is necessary that if you record the questions and the answers of the child, okay, then you make the observation. The appellate court will be in a position while deciding the appeal, while appreciating the evidence of that child witness, that yes, you see, this question has been put, he is answering like this, so he is giving rational answer. Yadu shadu bujikin douni tanu bujikin douchi tanu. Once the 118 says that how a child witness statement can be accepted, or how when the child witness can be said to be a competent witness.
My lord.
So the it is mentioned in 118 that all persons shall be competent to testify unless the court considers that they are prevented from understanding the questions put to them and from giving rational answers to those questions by tender year, extreme old age, disease, or whether a body or mind, and other cause of same kind. So ସେଥିପାଇଁ ଆପଣ ଖାଲି ଗୋଟେ ବ୍ରାକେଟରେ ଲେଖିଦେଲେ ଯେ ମୁଁ ୱିଟନେସ୍ କୁ ପଚାରିଲି, ୱିଟନେସ୍ ଉତ୍ତର ଦେଲା, ତେଣୁ ମୁଁ ସାଟିସ୍ଫାଏ ହେଇଗଲି ଯେ is a competent witness. That would not suffice. That would not have been done. At least some questions should have been mentioned that these were the questions put. Formal questions ହଉ ପଛେ କୋଉଠି ପଢୁଛ ସ୍କୁଲ ନା କଣ ପଢୁଛ, so rational answer ସେ ଦେଇପାରୁଛି କି ନାହିଁ, ତେଣୁ ତାହେଲେ ସିଏ observation ଟା ଇଏ କରିଥିଲେ ଠିକ ଅଛି, appellate court ଦେଖିବ। ଯଦି ସେଇଟା ହେଇନି, ଖାଲି observation ଆସିଛି, still then on that ground his evidence cannot be thrown, but we have to see that how far his evidence is acceptable or not. ଏଠି ଆମେ ଯଦି ସେକେଣ୍ଡ ଆସ୍ପେକ୍ଟ କୁ ଯେତେବେଳେ ପଳେଇ ଯାଉଛୁ, ସେତେବେଳେ ଆମେ ଦେଖୁଛୁ ଯେ ୱିଟନେସ ର କଣ ସବୁ ଆକ୍ସେପ୍ଟ କରିବା ପୂର୍ବରୁ କଣ ତା ଦେହରେ ସବୁ ଲ୍ୟାକୁନାଜ ରହିଛି ତା ଏଭିଡେନ୍ସ ରେ। What are the inherent improbabilities which are appearing? First of all, ଘଟଣା ଦେଖିଲା, ତାପରେ ଘଟଣା ଦେଖିକିନି ଅଜା ଆସିଛି ପଚାରିବାକୁ ମା ବିଷୟରେ, ସେ କହୁଛି ମା ଶୋଇଛି, ତା ନାକରୁ ରକ୍ତ ବାହାରିଛି। ସେତେବେଳୁ ସେ ଘଟଣା ଅଜା ପାଖରେ ଟୋଟାଲ କିଛି କହୁନି ଯେ ବାପା ମା କୁ ବାଡେଇଛି, ହେଲା। ଆଉ ଦେନ୍ ସେକେଣ୍ଡ ଥିଙ୍ଗ, ପୋଲିସ ଷ୍ଟେଟମେଣ୍ଟ ହବାର 4-5 ଦିନ ଆଗରୁ ଯାଇକିନି ଅଜା ଘରେ ରହୁଛି। ଅଜା ଆଈକୁ ଚୁପଚାପ ରହୁଛି, କିଛି କାହାକୁ କହିନି ଯେ ମୁଁ ଦେଖିଛି ଘଟଣା। ଅଜା ଆଈ ତାକୁ ଧରିକିନି ଯାଇଛନ୍ତି ପୋଲିସ ଷ୍ଟେସନ, ତାଙ୍କର ପ୍ରେଜେନ୍ସରେ ସେ ଷ୍ଟେଟମେଣ୍ଟ ଦେଇଛି, ହେଲା। तो डिले डिस्क्लोजर जोटा आछे। नेक्स्ट जहा स्टेटमेंट से दउची कोर्ट रे, आमे यदि ताकू प्रीवियस स्टेटमेंट अर्थात 161 स्टेटमेंट सहित आमे देखिबा, देन बहुत जिंस से एक्साजरेटेड वर्सन आनुची, लाइक इंजेक्शन देइकिनी बापा कहला ताकू सुआई देइची बापा से डेड बॉडी को नेइकिनी गला से जगार पोती देला एगुड़ाक सब किछि ता स्टेटमेंट रे नाही जोटा कि बाहरी प्रूव होइछि आयो जरिया तेणु केवल we are not telling that merely because no question answer has been recorded, this witness is to be discarded. So these are the other circumstances which create a doubt that whether, particularly when the child witness are prone to tutoring, ହେଲା ତେଣୁ possibility ଅଛି ଏବଂ ଏଇ circumstance ଯାହା ଆଣିଲେ ତାର ଯାହା previous conduct ହଉଛି ଆଉ ତାକୁ ଏମାନେ ଯୋଉ ନେଇକିନି ଯାଇଛନ୍ତି ଏବଂ ଇଏ କରିଛନ୍ତି ତେଣୁ ପସିବିଲିଟି ରହୁଛି ଯେ ତାକୁ ଟ୍ୟୁଟର କରି କିଛି କୁହାଇ ଯାଇଥାଇପାରେ ହେଲା ଯେ ତୋ ମାଆକୁ ସେଇ ମୁଣ୍ଡ ତୋ ମାଆକୁ ସେଇ ବାପା ହିଁ ମାରିଛି ତାକୁ ଇଏ କରିଛି ପୋତିଛି ତେଣୁ ତୁ ଯଦି ନ କହିବୁ ତୋ ମା ହୁଏତ ବିଭିନ୍ନ ଜିନିଷ ହୁଏତ କହିଥା 10 ବର୍ଷର ପିଲା ତେଣୁ ପସିବିଲିଟି 10 ବର୍ଷ ନୁହେଁ 10 ବର୍ଷ when he deposed in court
Yes.
8 years
8
when the statement was given before police ତେଣୁ 8-9 years ବେଳେ ତେଣୁ ଏ ଟାଇପ ର ପିଲାଙ୍କୁ ସେଇଥିପାଇଁ ଏଇ ଯୋଉ ଅବଜରଭେସନ ଆସୁଛି ଯେ ଯେ because of that the court has to be extremely careful while dealing with the evidence of a child witness
My lords.
and ଆପଣଙ୍କର ସେଇ ଯୋଉ ଡିସିସନ ଟା ଦେଇଛନ୍ତି ମଧ୍ୟ paragraph 44 ରେ ଲେଖା ହେଇଛି that is that the evidence of a child witness has to be subjected to closest scrutiny
Gotcha.
and can be accepted only if the court comes to the conclusion that the child understands the question put to him and he is capable of giving rational answer. A child witness, by reason of his tender ear, is a pliable witness. He can be tutored easily, either by threat, coercion, inducement. Therefore, the court must be satisfied that the attendant circumstances do not show that the child was acting under the influence of someone or was under threat or coercion. Evidence of a child witness can be relied upon if the court, with its expertise and ability to evaluate the evidence, comes to the conclusion that the child is not tutored and is evidence as a ring of truth. It is safe and prudent to look for corroboration for evidence of child witness from the other evidence on record, because while giving evidence, a child may give scope to his imagination and exaggerate his version and may develop cold feet and not tell the truth and may repeat what he has been asked to say, not knowing the consequence of the deposition in court. Careful evaluation of the evidence of a child witness in the background and context of other witness of the case is a must before the court decides to rely upon it.
So, my lords, the only impress of truth that is there in PW's 2 version is that the father assaulted the mother, my lords. Because that is also corroborating with the medical evidence, your lordship. So, even though there are some material omissions, as your lordships have pointed out, this impress of truth still remains, my lords.
No, once we doubt, because after the dead body was exhumed
Lordship.
from the place of burial and it was subjected to postmortem. Now the doctor gave the opinion that how the death has taken place. So the doctor says that was fracture of ribs. It can be caused by this and this. So then the statement can be created like that. So there is no problem that body re marlam dekhili to apon koi diye bo je body re marchi se pouchi medical
But
evidence se
her
pouchi.
161 statement was recorded before the dead body
No,
was discovered.
date recording ଆପଣ ଆପଣ ଯୋଉ ଡେଟ୍ ଟା କହୁଛନ୍ତି ଯେ
My lords.
ଯେ ଡେଟ୍ ଟା ପଡିଛି 5 ତାରିଖରେ
Lordship.
but you see the child witness statement ଆପଣଙ୍କର ଚାଇଲ୍ଡ ୱିଟନେସ୍ କେବେ କହିଲା ଦେଖନ୍ତୁ ଆଉ ଥରେ ଆସନ୍ତୁ ସେଠି 8 to 10 days after the occurrence, I was examined by police.
Yes.
I was at Chahota house in my grandfather while I was examined. I went to the house of my grandfather 3 to 4 days prior to my examination. My grandfather and my grandmother tutored me to speak about this one. So, what is the forwarding report? You see,
My lords.
the accused was forwarded on 7/6. Hello? 7/6/2003. Your case is that the statement of this child witness was recorded on 5/6/2003.
My lords.
So what 167 CRPC requires? It requires that when you are forwarding the accused, you should send all the materials available on record, case diary, etc., statements, etc., so that the court will come to the conclusion that whether it is a fit case where the accused is to be taken on remand to judicial custody or not. That is the purpose for which 167 is there.
Lordship.
So if fifth statement, in fact, it was fifth, then when it was sent, two statements were sent on 161 statements. And those two statements are, one is Jaheda Khatun, signature is date is there, SDGM 7/6/2003, and the other is Giri alias Giridhari Mandal, that is 7/6/2003.
The accused.
Right? Two statements were forwarded with the forwarding report. So that is another factor to show that the statement of this child witness was not in existence. Had it been there, it would have been sent with the forwarding report. That law requires that it is to be sent. So that is another feature, that perhaps the statement was subsequently recorded, but it has been antedated. 7 तारीख पर्यंत ए स्टेटमेंट रेकर्डिंग हेई नथिला, एटा परे रेकर्डिंग हेइगिनी 5 तारीख देखाइछि, कारण यदि 5 तारीख रेकर्डिंग हेई थांदा 7 तारीख जेतेबेले अक्यूज फॉरवर्ड हला, एगुडा को फॉरवर्ड जेतेबेले हेइछि सेतेबेले ताकू भी फॉरवर्ड कर देता. So that is another statement. There are number decision to that effect also. Take down. JCRL number 44 of 2005. The appellant Giri alias Giridhari Mandal faced trial in the court of ad hoc additional sessions judge, fast track Jajpur, in sessions trial number 728 oblique 45 of 2003 for offences punishable under section 302 and 201 of the Indian Penal Code on the accusation that on 28 oblique 29 5 2003 at Jarka under Dharmasala police station in the district of Jajpur, he committed murder of Chandi Bibi, bracketary hereafter the deceased, by intentionally causing the death and knowing or having reason to believe that an offense has been committed, comma, he caused the evidence to disappear with the intention of screening the offense. From legal punishment. The Lennon trial court found the appellant guilty under both the offenses and sentenced him to undergo imprisonment for life and to pay a fine of rupees 100 in default of payment of fine, to undergo further imprisonment for 3 months under section 302 of the Indian Penal Code, and to undergo RI for 3 years and to pay fine of rupees 100 in default, to undergo RI for 3 months for the offense under section 201 of the Indian Penal Code, and both the sentences were directed to run concurrently. The prosecution case, as per the first information report lodged by Sheikh Asimuddin, bracketary PW3, comma, the uncle of the deceased, on 5/6/2003, before the inspector in charge of Dharmasala police station, comma, in short is that the appellant and the deceased married 12 years prior to the occurrence, and it was a love marriage, and the appellant was having a poultry shop, and they were living happily. However, sometimes there used to be quarrel between the couple, and the dispute was sorted out at the instance of PW3 and others. The deceased used to come to the house of PW3 to ascertain his well-being. About 10 days prior to the lodging of the FIR, since the deceased didn't come to visit PW3, the latter went to the house of the appellant to meet the deceased. But he was informed by the appellant and his younger brother that the deceased was sleeping, and PW3 was asked to come afterwards. Stop. PW3 asked his granddaughter, bracket PW2, about the deceased, who told that the deceased was bleeding from his nose. Stop. PW3 thought that on account of summer season, there might have been bleeding from the nose of the deceased, for which he did not try to meet the deceased and return back. Since thereafter the deceased did not come to meet him, PW3 became suspicious that the appellant might have committed murder of the deceased, for which the whereabouts of the deceased could not be ascertained. Subpara. On the basis of such first information report, Dharmasala PS case number 147, dated 5/6/2003, was registered under section 302(201) by 34 of the Indian Penal Code. And the inspector in charge directed PW12 MD Jahed Hossain, the SI of police attached to Dharmasala police station, to investigate the case. During investigation, PW12 examined the informant, and on 5/6/2003 at about 3:30 p.m., he visited the spot and examined other witnesses. He also searched the house of the appellant in presence of the witnesses and seized bloodstained earth, sample earth from inside the bedroom of the house of the appellant, and prepared seizure list exhibit 5. Keeping a guard at the spot, PW12 searched for the appellant but could not get a trace of him. On 6/6/2003, getting some reliable information, PW12 proceeded to Jarka Bazaar and apprehended the appellant there. At 2 p.m., while in police custody, the appellant stated to have concealed the dead body under earth at the backside of his house at Jarka Bazaar and led PW12 and other witnesses to that place, pointed out the place where the dead body was concealed. PW12 sent requisition for the executive magistrate and medical officer, and on arrival of the executive magistrate and medical officer, the place which was pointed out by the appellant was dogged with the help of the informant, bracketed PW3 and others, and the dead body was exhumed, exhumed, HUME. The dead body was identified by the informant and others to be that of the deceased. PW12 conducted inquest over the dead body and prepared inquest report Exhibit 3. He handed over the dead body to the medical officer who was present there to conduct post-mortem examination, since the dead body was in a highly decomposed state. He prepared the spot map Exhibit 8. On 7/6/2003, he forwarded the appellant to court. He sent requisition to the Tahsildar for demarcation of the spot house and the place of recovery of the dead body. He received the post-mortem report and made certain queries to the medical officer and got the reply. He sent the bloodstain earth and sample earth collected during course of investigation for chemical examination through the London SDGM Jajpur, and received the demarcation report of the RI, and on completion of investigation submitted charge sheet against the appellant. The defense plea of the appellant is one of denial, and it is stated that the deceased was not staying with him. He was in her father's place and she died there. And a case under Section 498A IPC was instituted against him for which he has been falsely implicated. In order to prove its case, the prosecution examined 12 witnesses. The prosecution also proved 10 documents. From the side of the defense, the judgment passed in GR case number 451 of 2000 was marked as Exhibit A. The London Trial Court after assessing the oral as well as documentary evidence on record, came to hold PW2, the child witness, to be a truthful witness, and found no material that he was in any way tutored, influenced, or molded to speak falsehood. The court accepted the medical evidence adduced by PW1 and came to hold that the medical evidence corroborates the evidence of PW2 in all material particulars. The court further held that the dead body of the deceased was recovered from a ditch situated at the backside of the house of the appellant. In a highly decomposed state. In paragraph number 10, the learned trial court summed up the circumstances appearing against the appellant as follows. Quote कर दो बेटा. The court also accepted the evidence of PW4 and 5 who have stated about the extrajudicial confession made by the appellant before them to have killed the deceased. And accordingly came to the conclusion that it was the appellant who assaulted the deceased and killed her, causing fracture of the ribs and the associated internal injury, and then concealed the dead body of the deceased after committing the murder by burying it in order to screen of himself from legal punishment. Mr. Abhay Kumar Parida, learned an amicus curiae, appearing for the appellant, argued that the London trial court has not recorded what questions have been put to the child witness bracket PW2 and what answers he gave to such questions, and merely mentioned in the deposition sheet that he tested the veracity of PW2 by putting some intelligent questions and found that she was giving rational answers. According to Mr. Parida, the opinion of the London trial court that PW2 is a competent witness and that she is able to give rational answers is not final. It is subjected to scrutiny by this court in exercise of its appellate jurisdiction, and therefore it was nonetheless duty of the London trial court to record the specific questions put to PW2 and answer given by her. Land Council further argued that the delayed disclosure of the occurrence by PW2 and non-disclosure of the occurrence even though she was staying in the company of her grandparents creates doubt about the truthfulness of her version. And there is every possibility of tutoring to PW2 by her grandparents to depose falsehood against the appellant. Since the appellant was prosecuted for an offense under Section 498A of the Indian Penal Code for assaulting the deceased. It is further argued that PW2 has made exaggerated statement in court regarding the appellant telling her that the deceased was sleeping on account of application of injection on her, and that the appellant carried the dead body of the deceased to the backside of her house and buried under the earth. It is further argued that though the investigating officer has mentioned that the statement of PW2 was recorded on 5/6/2003, but when the accused was forwarded to court on 7/6/2003, only two statements were forwarded along with the forwarding report, but the statement of PW2 was not forwarded, which shows that the 161 CRPC statement of PW2 was not in existence till the appellant was forwarded to court on 7/6/2003, and it has been created subsequently but antedated. Stop. The London Council further argued that so far as leading to discovery of the dead body is concerned, PW 10 and 11 didn't support the prosecution case, and PW 3, the father of the deceased, and PW 12, the IO, have stated in that respect. However, there are a lot of discrepancies in the statements of these two witnesses regarding arrest of the appellant, regarding the timing of arrest of the appellant, the timing of making the statement under Section 27 of the Evidence Act, and moreover, the statement given by PW3 that after the disclosure statement made by the appellant, he accompanied the police and other witnesses to the place where the dead body was dug out from the earth is not acceptable, since he has stated that after such recording he went home. The Land Council further submits that so far as the extrajudicial confession before PW4 and PW5 are concerned, there was no reason assigned as to why the appellant would repose confidence on these two witnesses and disclose about the occurrence before them. There is nothing on record that PW4 and PW5 were very close to the appellant. And moreover, the conduct of PW4 and PW5 after such extrajudicial confession was made by the appellant before them in non-reporting the matter to the police and even to the father of the deceased, that is PW3, makes their version suspicious, more particularly when they gave their statements 5 days thereafter. So you leading to discovery city I would add further. The Land Council further submits that even if it is the prosecution case that after the dead body was recovered at the instance of the appellant, the inquest report was prepared, but there is nothing in the inquest report to show that at the instance of the appellant, such body was recovered. Even no signature of the appellant is there in the inquest report bracket exhibit 3. The London Council further argued that even though some earth stated to have been bloodstained were seized from the house of the appellant and it was sent for chemical examination, but the C report has not been proved. And therefore, it cannot be said that the prosecution has established its case against the appellant beyond all reasonable doubt, and therefore it is a fit case where benefit of doubt should be extended in favor of the appellant. Mr. S.K.MISHRA Land Council appeared, and an additional standing counsel, on the other hand, supported the impugned judgment and argued that even though the questions put and the answers given by the child witness PW2 has not been mentioned in the deposition sheet, but the fact that the London trial court was convinced that she was giving rational answer and the manner in which she answered to the questions put by the public prosecutors who also the London Defense Counsel indicate that she was quite mature and therefore the London trial court has not committed any illegality in holding her to be a competent witness. Land Council placed reliance in the case of Gorapurti versus State of Orissa, 2016 SCC Online, Orissa 133. It is further argued that since the witness was of tender age and she saw the ghastly crime being committed by none else than the father of her father, she must be in a state of shock. So also in fear, and therefore in such a situation, the delayed disclosure cannot be a ground to reject his evidence. More particularly when or evidence that the appellant assaulted the deceased with a thenga on her chest is getting corroboration from the medical evidence, and PW1, the doctor has stated that he noticed a fracture of the left wrist joint, so also fracture of 5th, 6th, 7th, and 8th ribs anteriorly on the right side, and further stated that the mode of death was due to shock caused by extensive chest injury, which were antemortem in nature, and further opined that the injuries sustained were possible by hard and blunt weapon. The London Council further submits that the 161 CRPC statement of PW2 itself indicates that it was recorded on 5th of June 2003. And merely because there was laches on the part of the investigating officer in not sending such statement on 7/6/2003, when the appellant was forwarded to court, the same cannot be a ground to hold that the statement was non-existent as on 7/6/2003, and it was subsequently created but antedated. The Land Council submits that even though PW10 and PW11 have not supported the prosecution case regarding the leading to discovery of the dead body from the place of burial, but the evidence of PW3 and PW12 are very convincing, and the inquest report also indicates that it was recovered from a burial position. And the London trial court was quite justified in accepting the evidence of these two witnesses, that is PW3 and PW12, that on the basis of the statement of the appellant recorded under Section 27 of the Evidence Act, the dead body of the deceased was recovered from the place of burial. It is argued that this circumstance is a very clinching one, as the appellant had exclusive knowledge in that respect, and the finding of the London trial court on this aspect cannot be doubted. Land Council further argued that PW4 and PW5 are two independent witnesses. They have no acts to grind against the appellant, and then they have stated about the extrajudicial confession being made by the appellant before them to have killed the deceased, and nothing has been elicited in the cross-examination to disbelieve such evidence, the London trial court has not committed any illegality in accepting such evidence. The Land Council submitted that in view of the evidence of the eyewitness PW2, the medical evidence adduced by PW1, the extrajudicial confession made before PW4 and 5, the leading to discovery of the dead body, which has been deposed to by PW3 and PW12, it can be said that the prosecution has proved beyond all reasonable doubt that the appellant was the author of the crime and he has committed murder of the deceased and caused disappearance of evidence by burying the dead body in the backyard of the house near a pond. And therefore, the JCRLA should be dismissed. The case mainly rests on the evidence of the child witness PW2, who is the daughter of the appellant and the deceased and granddaughter of the informant, bracketed PW3. Section 118 of the Evidence Act envisages that all persons shall be competent to testify unless the court considers that they are prevented from understanding the questions put to them or from giving rational answers to these questions because of tender years, extreme old age, disease, whether of mind or of any cause of the same kind. A child of tender age can be allowed to testify if he has intellectual capacity to understand questions and to give rational answers thereto. The decision on the question whether the child witness has sufficient intelligence primarily rests with the trial judge, who notices his manners, his apparent possession or lack of intelligence, and the said judge may resort to any examination which will tend to disclose his capacity and intelligence as well as understanding of the obligation of an oath. The decision of the trial court may, however, be disturbed by the higher court if from what is preserved in the records, it is clear that his conclusion was erroneous. The precaution is necessary because child witnesses are amenable to tutoring and often live in a world of make-believe. Though it is established principle that the child witnesses are dangerous witnesses as they are pliable and liable to be influenced easily, second, and molded, but it is also an accepted norm that if, after careful scrutiny of their evidence, the court comes to the conclusion that there is impress of truth in it, there is no obstacle in the way in accepting the evidence of the child witness. Bracket to reference Nibruti Pandurang Kokate versus State of Maharashtra, 2008, bracket with a bracket by 39, Orissa Criminal Reports SC 928. The evidence. The evidence of child witness has to be subjected to closest scrutiny. And can be accepted only if the court comes to the conclusion that the child understands the question put to him and is capable of giving rational answers. A child witness by reasons of tender age can be tutored easily, either by threat, coercion, or inducement. Therefore, the court must be satisfied that the attendant circumstance do not show that the child was acting under the influence of someone or was under threat or coercion. Evidence of the child witness can be relied upon if the court, with its expertise and ability to evaluate the evidence, comes to the conclusion that the child is not tutored and his evidence has a ring of truth. It is safe and prudent to look for corroboration for the evidence of the child witness from other evidence on record, because while giving evidence, a child may give scope to his imagination and exaggerate his version and may develop cold feet and not tell the truth and may repeat what he has been asked to say, not knowing the consequence of the deposition in the court. Careful evaluation of the evidence of a child witness in the background and context of other evidence on record is a must before the court decides to rely upon it. Bracket reference K. Venkatesh Warlu versus State of Andhra Pradesh, that is 2012, volume 53, Orissa Criminal Reports, SC 443. In this case, admittedly, the London Trial Court has not recorded what questions have been put to the witness and what answers have been given by her. Witness by bracketed legend PWQ. Though the court has observed that it tested the veracity of the witness by putting some intelligent questions and found that she was giving rational answers to it. We are of the view that the court should have specifically mentioned the questions put and the answers given by PW2 in the deposition sheet itself. And on the basis of such questions and answers, it should have mentioned whether the witness is a competent witness and whether she was giving rational answer and whether she was a competent witness or not. In as much as the finding of the London Trial Court that the witness is able to give rational answers is subjected to scrutiny by the appellate jurisdiction, and if the questions and answers are not recorded, it would be difficult for the appellate court to assess such important aspect. However, law is well settled that merely because the questions and answers have not been mentioned and the trial court has made the observation that about its satisfaction that the witness was giving rational answers, therefore he or oblique she was a competent witness, comma, that would not be a ground to discard the evidence. The manner in which he faced the questions put by the public prosecutor, answered to it, and also faced the cross-examination of the learned defense counsel can be looked into by the appellate court to come to a finding whether the observation made by the learned trial court that the witness was giving rational answers, he oblique she is a competent witness, is correct or not, and whether the evidence is to be accepted or discarded. PW2 has stated that while she was sleeping inside the house, she heard cry of the deceased and woke up and saw the appellant was assaulting the deceased by means of a thenga on the chest. She further stated that she cried and the deceased asked her to provide water, but the appellant denied to give water to her. And thereafter, the deceased repeatedly asked her for water and ultimately she died. PW2 further stated that the dead body of the mother was lying inside the said room for 2 days and the appellant told that sleeping injection was applied to her for which she was sleeping, and she further stated that 2 days after the appellant carried the dead body of the deceased to the backside of their house and buried under the earth. When PW3 came to the house of the appellant to meet her, as she was not visiting him for some days, comma, at that point of time, PW3 met PW2 and asked him about the deceased, to which PW2 stated that there was bleeding from the nose of the deceased for which she was sleeping. She did not disclose before her grandfather bracket PW3 that she had seen the assault by the appellant on the deceased. And that the deceased was asking for some water, but the appellant prevented her from giving water to the deceased. The statement made by PW2 that the appellant told that sleeping injection was applied to the deceased, and further she found that the appellant carried the dead body of the deceased to the backyard of the house and buried there, are the statement which have been made for the first time in court. And it has been the previous statement of PW2 has been confronted to PW to her and proved to the investigating officer that no such statement have been made by her before police at the time of investigation. PW2 has stated that she went to the house of her grandfather, bracket PW3, 3 to 4 days before her examination by police. However, she did not tell about the disturbance between her father and mother to PW3, so also to her grandmother. She further stated that her grandfather, bracket PW3, and grandmother asked her about the occurrence, but she did not tell them anything. Therefore, not only at the first instance, PW2 did not disclose anything before PW3 to have seen any assault by the appellant on the deceased. But when she continued to stay with her grandfather, bracket PW3, there also she did not make any disclosure to be an eyewitness to the occurrence. She has stated that when that her grandfather and grandmother took her to the police and she was examined by the police at the police station, and her grandfather and grandmother were present near her at the time of such recording. In view of the discrepancies which we noticed in the evidence of PW2, that is non-disclosure of the occurrence at the first instance before PW3, non-disclosure of the occurrence before PW3, so also before her grandmother, material contradictions as pointed out in the above to show that she is making exaggerated version, and since the possibility of tutoring PW2 could not be completely ruled out, we are of the view that her evidence cannot be accepted to be reliable and truthful. The statement, though shown to have been recorded on 5th of June 2003, is another doubtful feature, in as much as when the appellant was forwarded to court on 7/6/2003, though other statements were forwarded on which the signature and date of the London SDGM are there, but the statement of PW2 was not forwarded. Therefore, the possibility of such a statement being created afterwards, making it antedated, cannot be ruled out completely. Coming to the evidence of leading to discovery, which is deposed to by two witnesses, that is PW3 and the IO PW12, we find that there are discrepancies in the version of these two witnesses as to when such a statement was made, where it was made, and the version of PW3 to be a witness to the leading to discovery is also a doubtful feature. PW3 has stated that he was examined by the police on 5/6/2003, and on the same night the police brought the appellant to the police station, and during that night the appellant remained in the police station, and on 6/6/2003 morning, when the police asked, the appellant gave his statement at about 9, and when the police called the PW3 to the police station on the next day morning at about 5 to 6 a.m. And when the police asked the appellant to give his statement, he gave the statement at 6 a.m. and thereafter he returned back to his house. PW12, on the other hand, stated that on 6/6/2003, getting reliable information, he proceeded to Jarka Bazaar, arrested the appellant at about 2 p.m. and the appellant, while in police custody, made the disclosure statement and led him and the other witnesses to the place where the dead body was concealed. Therefore, whether the appellant was taken into custody on 5/6/2003 or 6/6/2003 is a doubtful feature. Whether the appellant made the statement on 6/6/2003 at about 6 a.m. or made the statement on 6/6/2003 in the police station, or on 6/6/2003 at 2 p.m. at Jarka Bazaar is another doubtful feature. If PW3, according to his own statement, came back to his own house after recording of this statement of the appellant, then is evidence in chief examination that the appellant led the police and the witnesses to the place of concealment and gave recovery to the dead body is very difficult to be accepted. Moreover, it is the prosecution case, as per the evidence of PW12, that immediately after the dead body was recovered from the place of burial, the inquest report Exhibit 3 was prepared. In the inquest report, there is no mention anywhere that at the instance of the appellant, the dead body was recovered. The signature of the appellant is also not there in the inquest report. In the case of Jawaharlal Das versus State of Orissa, reported in, what is the reference, Mr. Mishra?
1991. 1991 SCC.
Year 1991, Supreme Court. Page 1388. One of the circumstances against the appellant, against the accused, was that the dead body of the deceased was recovered on his showing, and the accused pointed out the place where the dead body of the deceased was lying inside a paddy field. The Honorable Supreme Court inter alia held that PW4 deposed that the dead body of the deceased was found lying in a paddy field and that the police held inquest over the dead body in his presence, and the inquest report is P.1 in which he put his signature as a witness. If really the body was discovered at the instance of the accused, there should have been a panchanama and mention about the same in the inquest report. The Honorable Supreme Court further held that since there is no reference to the accused in column number 9 of the inquest report, where the information of the witness as to the cause of death is noticed, and even though the purpose of the inquest report is only to ascertain the cause of death, but in a case of this nature, there should have been at least a mention in the inquest report as to how the body was discovered. Therefore, the Honorable Supreme Court didn't place reliance on this evidence. In the case in hand, since the timing of arrest, the timing of recording of the statement of the accused, the place of recording of the statement accused, are discrepant, and there is every doubt that PW3 had not accompanied the police party to the place of occurrence. We are of the view that it is difficult to accept the prosecution evidence that at the instance of the appellant, the dead body was exhumed from the place of burial. Coming to the extrajudicial confession, which is deposed to by PW4 and PW5, there is nothing on record that the appellant was very close to any of them. If according to the prosecution case, the appellant was maintaining all kind of secrecy in burying the dead body after committing the crime, then what was the reason behind making extrajudicial confession in a marketplace before PW 4 and 5 and others. The PW4 has stated that the appellant was talking like a madman at that time. PW5 has stated that Dharmasala police station is just half kilometer away from his house, and the tea stall where they were sitting is also at a distance of half kilometer from the police station. He further stated that the house of PW3 is at a distance of 300 feet from his house. After hearing the alleged extrajudicial confession, no attempt has been made either by PW4 or by PW5 to report the matter before the police or to or disclose about it before PW3, and they gave their statement 5 to 6 days thereafter. This creates doubt about the version of PW4 and PW5. Even though some bloodstain earth and sample earth were collected from the house of the appellant, which was sent for chemical examination to the Director FSL Rasulgarh Bhubaneswar through London SDGM Jajpur. But the C report has not been produced during trial. Therefore, the seizure of this earth becomes inconsequential. In view of the foregoing reasons, we are of the view that when the version of the child witness is a doubtful feature, when the evidence of leading to discovery of the dead body from its burial position by the appellant is shrouded in mystery, and the extrajudicial confession stated to have been made before PW4 and PW5 is not acceptable in view of the reasons already assigned. We are of the view that cannot be said that the prosecution has successfully established its case beyond all reasonable doubt against the appellant. Therefore, accordingly, the jail criminal appeal is allowed. The appellant is acquitted of the charges under section 302 and 201 of the Indian Penal Code. It appears that the appellant was released on bail by this court during the pendency of the appeal. He is discharged from the liability of the bail bond. The surety bond stands cancelled. Put a note of appreciation on Mr. Farida and also Mr. Mishra. The amount of rupees 15,000 which has been deposited by the appellant before the registry as per the order of this court dated 9/12/2014 on 8/2015 এটা কোন 8/5 ডিপোজিট হয়েছে আচ্ছা
Filed, late be accepted.
আচ্ছা
Filed, late be accepted. Late filing to accepted by order basis. Court accepted. Anything of within 2 weeks.
না এটা কেবল ডিপোজিট হয়েছে
Deposit at foreign.
না এটা ডিপোজিট হয়েছে 8/5 রে অ্যামাউন্ট
Invest
15/5 রে
order होला पर 15 next step renew होगा था 8/500
খালি করে ডেট দেবেন
Yeah.
deposited
With
as per the
accrued
order
interest,
with accrued interest we return to the appellant
within a period
within a period of 4 weeks করবেন তাহলে within a period of 4 weeks.
মানে টাইড ম্যাটার
টাইড অফ বেল ম্যাটার
শুক্রবার
अर्जंट मैटर वाली 5 तारीख को काली को
এসসি এসটি অপিল ম্যান
काली को
Adyon
শুক্রবার।
ऑनर्स नॉट काली
বেলচো ম্যান
লিস্ট মিলার
টাইড অফ ম্যাটার ইউর লর্ডশিপ
please
and another modification of order.
My lord, this BLAPL has been delisted. This came up 3 times in the list. The petitioner is in custody since 2 years, my lord.
must be interim application for stay of the order of conviction lordship.
Let's say tied up well matter.
item 44 it is meant for interim bail খালি instruction ଆସିବ daughter of the Miller appellant Miller suffering from blood cancer. First time listed I saw the IA number Miller 2980
44
44 Miller
what is the IN number
2980 Miller
we କଣ
ଖାଲି instruction ପାଇଁ ରହିବ first time ଆସିଛି 44 daughter of the appellant Miller suffering from blood cancer.
44 item number IN number 2980 of 23. This is an application for interim bail on the ground of ailment of the daughter of the petitioner. The learned counsel for the state seeks some time to obtain instruction put of this matter. Good saptah pore rakh din.
15 টা 1 week after Miller 15 item টা
40 kete koile era
44 Miller
44 interim bail at 2980. Okay, 1 week after inspection. कौन है आउट कौन
और 15 ଟା 1 week after Miller SC ST trial deposition
notice ଯାଇଛି
ହଁ notice ହେଇସାରିଛି
ପାଇ ଯାଇଛନ୍ତି କେସ୍ ଡାଏରୀରେ ଅଛି ନୋଟିସ୍ ସଫିସିଏଣ୍ଟ ହେଲା କେସ୍ ଡାଏରୀ ଅଛି all right the learned counsel for the state submits item 15 that notice has been made sufficient on the respondent number 2 and he has also received case diary. Learned counsel for the appellant seeks for an adjournment March में सिर्फ पके दिन. Yes.
My lord, supplementary list item number 2, my lord. Lord, I have filed an interim application today itself.
Wait, when the matter reaches me, yes.
My lord, item number 10, supplementary item number 10, my lord, permitted to withdraw. 10, my lord.
CRLA number 47
My
of
lord.
2021.
My lord, permitted to withdraw, my lord.
Learned counsel for the appellant files memo for withdrawal of the CRLA disposed of as withdrawn. Yes.
Much obliged.
Yes.
Supplementary list item number 1.
May I please, Lordship, my lords. All the appeals, my lords, are arising out of common trial, my lord. That is city number 43 of 2022, my lord. So far that criminal appeal number 1149 of 2023 and 1155 of 2023, both appeals have already been admitted by my lord, and a record was called for as the connecting record is available in connection with the criminal appeal
So
number.
go by one.
Yes, ma'am.
1150 of 23.
Yes, ma'am.
Has it been admitted?
That has goes today for the admission, my lord.
Okay, hard admit. Next, this. What is the sentence imposed?
Sentence imposed is 7 is, my lord.
Yes.
They were facing the trial being charged under section 302 and 34 of Indian Penal Code, my lord. Learned 302, 307 and 34 of the Indian Penal Code. Learned trial court acquitted all the appellants under
All right,
section.
supply the deposition copies.
I have already supplied, and
Yep.
one of the co-appellants, my lord, that is also I have also supplied that copy to the Learned State Council and to the Honorable Court. That is also part of the record. He has already been admitted to bail, my lord. That is criminal appeal number 1114. That is available in the record, my lord. Finding of a trial court is in page number 41, paragraph number 18 of the judgment.
So that man was released on bail because
Yes, well.
he has not assaulted the deceased but assaulted to PW7.
Yes, well. So the assault to deceased has been attributed, my lord, against Baroda Behera alias Jani in connection with the criminal appeal number 1156 of 2023, my lord.
Jani assaulted the deceased by
Yes, my
means
lord.
of a split
Yes,
bamboo.
yes, my lord. I want to invite my lord.
And Babu and Nabo dealt slaps and kick blows. Who is Jani?
Jani is the
Fourth appeal.
1156 of 2023, my lord.
And what about Babu?
Babu allegations.
Babu is slaps and kick blows.
Yes, my lord. That is not the cause of death, my lord.
Mr. Das, have you got this bail order copy of the co-accused?
No.
Sanatan
The
Das.
class order.
Alias Ton. ସନାତନ ଦାସର ବେଲ୍ ଅର୍ଡରକୁ ପଳେଇ ଆସନ୍ତୁ ସବମିଶନକୁ ଆସନ୍ତୁ Learned Counsel for the petitioner submits that the petitioner was on bail ଏଟା ସମସ୍ତଙ୍କ ପାଇଁ applicable. Then he further submits that eyewitness PW7 has stated that co-accused person so and so Jani ବର୍ତ୍ତମାନ ହଉଛି one of the appellant in CRLA 1156.
Yes,
then Babu is the CRLA 1150 and Nobbo is
not
here. Okay. Scolded the deceased and Jani assaulted the deceased by means of split bamboo, botta. Babu and Nobbo dealt slaps and kick blows to the deceased. So far as the petitioner is concerned, in that criminal appeal, he has been implicated in the assault of that injured PW7.
Right.
And he gave kick blows and fist to that PW7. So, sole eyewitness
PW7
attributed overtact so far as that is against Jani.
Paragraph number 18 of the impugned judgment, my lord. Page number 41. Inner page number 41.
So, Jani ta thau tiye pore dekhiwa
yes, ma'am. Yes, ma'am.
ये सब same trial face करथिले
same trial, man.
All right, take down 115023 admit kale तापरे IA number so and so is an application for bail. Learned Counsel for the petitioner submits that the petitioner was on bail during trial and he has never misutilized his liberty. He further submits that the eyewitness PW7 has stated that the petitioner scolded the deceased, and along with co-accused Novoseti, he dealt slaps and kick blows to the deceased. However, the main allegation is against Borada Behera alias Jani, who assaulted the deceased by means of a split bamboo (bracketed botta). Learned counsel submits that one of the co-accused who was facing trial along with the petitioner, namely Shanatan Das alias Tona, has been directed to be released on bail in CRL number 1144 of 2023. As per order dated 22/1/2024, passed in IA number 2521 of 23, produces the bail order copy which is taken on record, and further submits that since there is no chance of early hearing of the appeal in the near future, the bail application may be favorably considered. Considering learned counsel for the state opposed the prayer for bail, place the evidence of 7 and PW6 who conducted so and so. Considering the submission made by the learned counsel for the respective parties, nature of evidence adduced during trial, nature of overt act attributed against the petitioner so far as the assault on the deceased is concerned, the fact that the petitioner was on bail during trial, and there is no material before this court that the petitioner has misutilized his liberty in any manner, and absence of chance of early hearing, I am inclined to release the petitioner on bail. Stay realization of fine. Bail granted. Stay fine. Okay, the next one is Pitavas.
Yes, ma'am.
What Pitavas has done?
So for that Pitavas, it is unless that I am placing PW7.
PW7 evidence टा दियंतु. State Council को देइछन्ति.
Yes, ma'am, I have already supplied.
Pitavas ना रे कोन अछि देखन.
Lordship Meklang the paragraph 18 of the impugned judgment, my lord. Trial court has also elaborately quoted.
PW7 evidence क्या है वो? एटा.
खोल के. Cross examination. खोल के दे.
Pitavas Polly.
Yes, ma'am.
Mr. Das, se Pitavas Polly ना कोन अछि कि?
Kallu.
हाँ?
No, only one name. Chobbi, my lord. Pitavas Pali alias Chobbi.
Chobbi?
Yes, my lord. After the impugned judgment, my lord. Appellant number, as accused number 1, my lord. Pitavas Pali alias Chobbi.
Chobbi Pali assaulted me by bamboo split.
हाँ तमने आकु मारची से जो PW7 को मारची जोड़ा की से जो लोकड़ा बेल ले जाइची सर. All right, the learned counsel for the petitioner submit that the petitioner was on bail and he has never misutilized his liberty. Placing the evidence of the eyewitness PW7, it is stated that the overt act attributed against the petitioner is that he assaulted PW7 by means of bamboo split. But there is no specific overt act against him to have assaulted the deceased. बाकी जो likelihood of so and so and co-accused has been released on जो 1144 so allow कर दियंतु. So admit ହେଇଥିଲା. अच्छा ଏଟା admit ହେଇଯାଇଥିଲା ତେଣୁ ଦେଖିବେ ଖାଲି bail grant कर देवे और stay realization of fine करते हैं. Yes, next.
Next is my lord Monorojan Valley
And also
alias
Kalu.
Same footing mail.
Kalu नार कौन अच्छी?
Same footing mail.
Kalu सत्यजीत नायक Kalu टोना
John
dealt
He's
fist and kick
to
blows
him.
to him. अच्छा और ये सेम फुटिंग अच्छी ताकू କହିଦେବେ ଲେଖିଦେବେ କାଲୁଟା କଲା କାଲୁ along with others କରିଦିଅନ୍ତୁ ମାନେ present petitioner ହେଲା along with others dealt fist and kick blows to him to PW7 ହେଲା बाकी समान ରହିବ no specific overtax so far as assault on the deceased is concerned बाकी सब ରହିବ ये ଏଟା admit ହେଇଯାଇଛି
admit ହେଇଯାଇଛି
अच्छा so bail granted stay realization of fine next Jani hochi pore like the put of this matter learn counsel for the state seek some time to obtain instruction about the criminal antecedent put of this matter 2 weeks after
let it be admitted matter
এটা admit ହେଇନି
ନାହିଁ
ଆଚ୍ଛା এটা admit କରିଦିଅନ୍ତୁ ହେଲା interim applications for stay and bail application to be considered after 2 weeks କରିଦିଅନ୍ତୁ ହେଲା then next
Satyajit Naik stands on the same footing my lord
Satyajit Naik Satyajit Kalu and Tonna dealt fist and kick blow same footing ହେଲା
it would be admitted
ତେଣୁ ଏଇଟା admit ହେଇନଥିଲା ଏଇଟାକୁ admit କରିବେ ଦେଖିଦେବେ ଯୋଉଟା admit ହେଇନି admit କରିବେ bail granted stay of realization of fine ए PW7 ର evidence ର copy ଗୋଟେ ଦେଇ ଦିଅନ୍ତୁ
yes my lord supply it obliged ସେଟା ଦିଆ ହେଇଛି ଖାଲି supply
ଏଇଟା ରଖନ୍ତୁ PW7 ର deposition କାରଣ refer ହେଇଛି ତ ନାଇଁ LCR ମଗା ହେଇନି ତ ନିଅନ୍ତୁ
Item number 2.
Yes, my please, Your Lordship. Lordship, I have filed an IA for
appellant convicted under section 20B 2IC of NDPS Act and sentenced undergo imprisonment for 10 years, madam, and fine amount 1 lakh.
All right, admit call for the trial court report. interim application for bail and stay realization of fine to be considered after receipt of the trial court or deposition copy to be supplied. Yes, next.
Obliged.
Item number 5.
May I please, my lord. So the appellant convicted for 10 years, my lord, for a commission of offense 304B.
One-year-old.
And what is the sentence?
4 years, my lord, for the offense under section 13(2), reduced section 13(1)(e). That is at page 98, running page.
Yeah.
And he is in custody right now, my lord.
You are on bail during trial.
My lords, my lords.
Yes, Mr. Das.
From the date of judgment, he has been remanded to judicial custody.
Yes.
Because of sentence of 4 years.
So he was earlier
on bail.
2024.
अच्छा अरेस्ट करने कराई नतला था. All right. The third admit Mr. Sanjay Kumar Das, Lion Standing Counsel for the Vigilance Department. So means that you will file the VNAMA appearance memo by so and so.
At the end of April.
Admit he was not arrested further during investigation of the case. After the pronouncement of the judgment, he was taken into judicial custody. So bail granted, stay realization of fine, free copy of the order be handed over, name of Mr. Das be reflected in the cause list henceforth. Yes, next.
Obliged.
And also in the cause list.
Yes, cause list.
Okay.
Item 8.
Yes, Mr. Das. Please give the names.
My lord. Given me.
All right. Admit. Next. Engaged.
A copy also not received by state.
So give a copy of the JCRL to the land count registry. Shall hand over a copy of the JCR. Yes, along with the impugned judgment. Yeah. The delay condoned. Admit. Advocate engaged. Yes.
Item 11.
Mr. Jena.
Item 11, Your Lordship, that has become infructuous. The petitioner has been released on bail.
Land counsel for the appellant submit that the matter has become infructuous. Accordingly disposed of. Yes, next.
Item 12.
Mr. Chan. Who is appearing for the respondent number 2. Mr. Dharanidhar Naik. You are for the informant.
Yes.
Yes. So you have received the case diary?
My lord.
Is it the first application or earlier rejected?
First application.
First application.
Latest status report we called for. My statement.
Latest
Status report we called for by the Supreme Court.
All right. Mr. Manas Kumar Chand, Mr. Dharanidhar Naik, and senior advocate. Manas Kumar Chand for the appellant, Mr. Dhananjay Naik for the informant. Land counsel for the appellant submits that the appellant is in judicial custody since
My lord, 18/7/2022.
18/7/2022. And he is not aware about the status of the case, and the status report may be called for. In view of such submission, let the status report be called for from the London Trial Court. File be placed before registered judicial. Matter be listed after 1 week. Yes, next.
Item 13.
Yes, Mr. Sharma. What is the defect? Defect number 7.
ଓଡ଼ିଆ
number
161
କୋଉଟା ଅଛି? ଯେ ତାରିଣୀ ଲେଖି ଦଉଛି କିଛି ପଡିବନି। ଆଚ୍ଛା ହଉ। Is a SC/ST matter?
SC/ST matter, yes.
Notice has been issued.
No, notice ଯାଇନି।
Sufficient. Notice out. Okay.
କୋଉଟା 13ଟା?
Bail application?
No, this is
It's not bail, my
It's a
lord.
challenging the cognizance.
I'm questioning the
Char-
order. I am questioning the order of cognizance taken under STSC Act. my lord.
So, when that cognizance order was taken?
3/5/2023. It is on the basis of a protest petition. FIR was filed. Police filed no charge sheet against me. Police said that it's a false case, out and out false case. Then a protest petition was filed.
You are the sole accused in that case.
Sir.
Now come to the operative part of the order.
Yes.
Page 32, my lord. 31.
That is mentioned that issue summons to the so and so.
That is 33.
As per the FIR, fixing the date of appearance on 16/5/23, and no stay order has yet been passed. So what happened from 16/5/23 onwards?
So then I'll take instruction because
Right, because if suppose in the meantime he has appeared or charge has been framed, then you are to amend your petition. That's why
then I have to file a different petition, my lord, questioning that framing of charge.
So, Lenin, the impugned order in this case is dated 3/5/2023, passed by the Lenin Special Judge Moyurganj, Baripada, in GR case number 80 of 2022. The impugned order reveals that the case was posted to 16/5/2023 for appearance of the appellant. The Land Counsel for the appellant is not producing the order sheet from 16/5/2023 onwards. Let a status report be called for. Put up this matter in the week commencing gote saptah par. Yes.
Item 14.
Sushant Kumar, I'll take it next week, my lord.
What is the CRLA for?
For my lord,
Bail.
SC/ST.
Bail matter.
Yes, my lord.
Notice should have been issued in this condemnation.
Yes, notice confirm.
You have received the case diary?
No, she did not receive. Yes, my lord, she did receive.
And what is the offense here?
Offense is 341, 294, 323, 324, 509, 307, 506, 31RS2 VA SCST Act.
So, who is that injured?
Injured Prakash Sethi.
Prakash Sethi.
Sethi.
What injury he has sustained?
Simple injury. One.
Any criminal antecedent against the petitioner?
That has not come.
IA number so and so. This is an application for condonation of delay. The Land Counsel for the state submits that notice on the informant has been made sufficient. None appears. Since it's a bail application, I'm inclined to take into account the submission made by the Land Counsel for the parties and the averments taken, I am inclined to condone the delay. Accordingly, delay is condoned, IA is disposed of. Considering the submission made by the Learned Counsel for the appellant that the appellant is in judicial custody since Kebed Royleni. Oh, you were on bail during this case. That the appellant was on bail in the case due to non-appearance on the date fixed. Non-bailable warrant of arrest was issued on 38/2022. बाकी सब बेल्जियम फॉर्मेट रे करी अलाउ कर देन. Yes, next.
Item 16.
In the meantime, I was kind enough to grant bail to co-accused. I'll get the copy. I'll pay for next week.
Learned counsel for the appellant submits
Hussein
that,
Khan has been granted.
one of the co-accused has been granted bail. The matter may be taken up next week in order to produce the bail order copy. You have received the case diary?
Yes, ma'am.
All right, learned counsel for this case submit that he has received the case diary. Put up this matter next week. Yes.
Item 17.
Mr. Mishra,
My lord, kindly call the matter after 1 week.
1 week. CD available?
CD is there.
CD available. Learned counsel for the appellant 6 for an adjournment. Urgent. Yes, next.
Informant is appearing.
Okay. Learned counsel for the informant is present. Yes, next.
Item 18.
May it please your lordship. The alleged occurrence took place on 11/7/13.
Notice sufficient.
Lordship, given the report, my lords, the informant was found absent, my lords.
Found report would be.
I had submitted an affidavit stating that I was in jail in Surat on 13/7/2000.
What instruction?
Yes, that instruction of received, my lords. He was in fact, as per the jail superintendent of Surat jail, he at time of occurrence of the crime, he was in custody, my lords. Both the instructions are.
The heard Mr. Basudev Pujari, learned counsel for the appellant. ये दीटा केस रे कॉमन ऑर्डर कर दे है ना ये दीटा केस गोटे ना अलगा अलगा केस
दुईटा पियस केस किंतु सेम इंसिडेंट
अच्छा अलगा अलगा करिए learned counsel for the state has produced written instruction received from IIC Kodola police station to the effect that the informant was found absent in his house, for which notice could not be served. The written instruction is taken on record. He has also produced यार दीटा कॉपी कर देवे अच्छा ये दीटा केस रे कोन सेम इन्फॉर्मेंट
नहीं इन्फॉर्मेंट अलग अलग
अब आपण बॉडी देले गोटे
इंसिडेंट सेम किंतु दुईटा
आपण कहिले एटा जोटा प्रथमटा देले
115
ता होची उमा प्रधान रे
माल 115
उमा प्रधान इज द इन्फॉर्मेंट को केस रे
पी महेश्वरी हेले 115 1270 रे
एटा उमा प्रधान ये राशि
देखो हम
उदला पीएस केस नंबर 116 रो इंस्ट्रक्शन आसी
माय लॉर्ड 116 टा 1271
116 ने क्या होची 1271 so Mr. Mishra,
my lords, yes, Uma Pradhan is the complainant, my lords, in 116.
जे what about the first one CRLA 1270 of 23
same date occurrence
same date जे तार informant अलगा ना तो
informant is different
एटा लिखि दियंतु CRLA
number arriving from the same
case 115 116
Dita ko 116 ଅଛି। Dita 116 ଅଛି। CD ବି ଗୋଟେ ହିଁ ଦେଇଛି।
Because there is a requirement of serving notice on the informant. 1271 there is no problem because you have already obtained. But for 1270 you have to make a statement that either it could not be solved or solved, whatever it may be. Or you have not taken instruction because the informant is different.
My lords.
Informant.
So
Both cases we have served it to the same this complainant.
କୋଉଟା?
ଦିଟା ଯାକ କେସରେ ଏଇ complainant କୁ notice ଟା ଦିଆ ହେଇଯାଇଛି। ଉମା
ନାଇଁ ଏଟା ଅଲଗାକୁ ଯିବ ଆପଣ ତାକୁ କେମିତି ପଠେଇବେ?
Lordship.
ଗୋଟେ ନେଇ ଆସନ୍ତୁ ଇଏଟା ଗୋଟେ ଯଦି ସିଏ ବି ନାହିଁ ସେ ଯୋଉ ଆର ଲୋକଟା
My
ଏ
lords.
କେସର ଇନଫର୍ମାଣ୍ଟ ସେମିତି ଲେଖାଟା ନେଇ ଆସନ୍ତୁ କଣ ଏଇଟା ଲେଖିଦିଅନ୍ତୁ ଏଇଟା ହଉଛି ସେକେଣ୍ଡ ଟ୍ୟାବ 1271 ହେଲା that notice could not be served on the informant respondent number 2 the written instruction is taken on record. The learned counsel for the petitioner submitted that there is omnibus nature of allegation against the petitioner and the petitioner is in judicial custody in connection with this case since kebetu acha and even though it is stated that the petitioner participated এটা আরেকটা বার করলো 1271 in the occurrence dated occurrence के ହେଇଥିଲା
13/7/2011
13/7/2011 however the petitioner was in judicial custody in Kodi
Surat. Surat jail.
in Surat jail
Lajpur Central Prison, my lords.
in Surat jail and therefore his implication in this case is nothing is completely false and therefore the petitioner may be enlarged, the appellant may be enlarged on bail. The learned counsel for the state has produced written instruction received from the jailer of Lajpur
Lajpur Central Prison.
Central Jail আছে Central Jail Surat from which it appears that the appellant was in the said jail from 5/6/2011 due to 31/3/2012. The written instruction is taken on record. Considering the submission made by the learned counsel for the respective party and absence of any specific overt act against the appellant and the report submitted by the jailer of Lajpur Central Jail Surat that on the date of occurrence, that is 13/7/2011, the appellant was in Surat Jail. I am inclined to release the appellant on bail. So this was second one is allowed. First one lekhibe. The learned counsel for the state submits that the matter may be taken up next week in order to obtain instruction regarding service of notice on the respondent number 2. ଏଇଟାର ଗୋଟେ କପି ଅଛି ତ ଆପଣ ପାଖରେ
Lordship.
କାରଣ ସେତେବେଳେ ଦେବାକୁ ପଡିବ ନା ଏଇଟା ଏଇ ରେକର୍ଡରେ ରହିଯିବ
My lords.
ଏଇଟା ନେକ୍ସଟ ୱିକ୍ କରିବ
Item 19.
My lord, it's a bail matter, my lord. Notice was issued. It was served.
Yes, Mr.
Lordship may grant me one more week.
Next week,
My lords.
Land Council for the state seeks for an adjournment till next week to obtain the case diary, instruction about the criminal antecedent, so also the confirmation letter regarding service of notice on the informant. Yes, next week.
Item 20.
May plus 3 to
What is the CRLF for?
CRLF for bail under the SC. Date.
3 dates, my lords. I contacted him yesterday only.
Next week, how time diya one?
Lordship.
Item 21.
Yes, Miss Nondo.
May I please? My bail for 368, my lord.
Bail matter.
My lord.
Notice sufficient ala? Oh, Mr. Panda is appearing, all right. So, is it the first application?
No, my lord. Second.
Second.
My lord.
So, what order was passed in the first application?
First application, your lordship said PW3, meanwhile, at that time, PW3 not examined. Order dated 26
9 to
9 2020.
That is CRLS 620 of
Name is Balaram Dale alias Raja.
My lord.
Raja Dale approved this court in CRL number 620 of 2022,
My lord.
right? So,
A common order was passed in the criminal law
jail
373.
custody in so and so. Okay. Charge sheeted 302 and 20B 34, 25, 27. Arms at 32 VA. Informant in this case is one Srinivas Naik, and the occurrence in question took place on such and such date, and the FIR was lost on the very day. FIR, the informant has not stated the name of Mickey alias Manoranjan Sahu to have participated in the crime. Submitted that on the very day of the lodging of the FIR statement under section 161 CRPC was recorded by the investigating officer. And in that statement also he has not stated named appellant Mickey alias Manoranjan, but named the appellant Raja Dale to have fired gunshot at the deceased Lala Pradhan. Eyewitness Pratap Naik also stated in the same. Both the eyewitnesses have been examined in the trial court as PW3 and PW7. PW7 not supported the prosecution case declared hostile. PW3 stated in the chief examination, appellant Raja and one Nikki arrived at the spot, fired bullets to the deceased, for which the deceased received gunshot injury. Further submitted, it has been confronted to the witness by the learned additional public prosecutor. After being declared hostile, he has stated before police that appellant friends opened fire 5 to 7 rounds, and due to gunshot injuries, deceased fell down on the ground. Further, no TI parade has been conducted to establish identity of any of the appellant. Okay. So ଜଣଙ୍କୁ ବେଲ୍ ଦିଆଯାଇଥିଲା ଏବଂ ଆପଣଙ୍କର ନାଁଟା ଯେହେତୁ ଦିଟା ଯାକ ଆଇ ୱିଟନେସ୍ କହିଥିଲେ
161.
ତାକୁ ହଁ ସେଇଥିପାଇଁ ରିଜେକ୍ଟ ହେଇଥିଲା। नो ଏଭିଡେନ୍ସରେ କହିଥିଲେ ପରା।
PW7 କହିଲା PW3 ର ଏଭିଡେନ୍ସ ଥିଲା और cross evidence ସେ not implicated the present appellant, my lord.
So it was rejected on
Rejected on
26/9/2020 ତାପରେ କଣ ଡେଭଲପମେଣ୍ଟ କଣ ହେଲା?
Development ହେଲା my lord running page 23 of my petition, my lord. Para 44
23
my lord.
हाँ
Para 44 my lord. When I reached at the spot, found my uncle deceased laying on the ground, sustaining bleeding injury. Many people gathered at the spot that is on the end point of our village. Dwelling houses as well as the shop are situated near the spot. I reached at the spot by 11 a.m. The police also reached at the spot and inquired about the incidents from the people present there. I know the accused person who are my co-villagers as well as nearby villagers. I had not seen any of them at the spot. I have also not seen Raja Dali accused in the spot. As per the villagers, I lost the affair. It is not the fact I am disposing falsehood, my lord. Meanwhile, all the co-accused person released on bail.
Mr. Tripathi से चीफ रे कहिकिनी गला तापरे क्रॉस एग्जामिनेशन ने स्टिक कला तापरे मिलामिशा आईगला पुणी ताकू रिकॉल पिटिशन दे देले से आसी मना कर दी चली गला जे मु ताकू जहाकू से मेन एलिगेशन करतला जे एही फायरिंग करतला
ये आउट निक्की
हां वर्तमान आसी गला मु से घटना जगह रे टोटल देखिनी should have filed appropriate petition to prosecute this man for perjury, giving false evidence.
And last occasion, Lordship, that time this cross-examination was not done. That is your Lordship rejected it.
So now he has stated, I have not seen.
Now he has stated.
Question is that
Yes, sir.
what would be the evidentiary value of this witness? That's a different matter. So 311 petitions would not have been allowed only for this purpose. That matter has been compromised. In a 302 case, you will call the person to nullify everything. Or the learned counsel for the petitioner, learned counsel
Only
for
thing
the
I
state.
pray, my lord, though he was a absconder, stringent conditions.
The learned counsel for the ମିଳାମିଶା ହେଇଯାଇଛି ମିଳାମିଶା ହେଇଯାଇଛି ନହେଲେ ଏମିତି କେମିତି ହବ ମେନ୍ ଆକ୍ୟୁଜ କୁ ଆପଣ କହିଦେଲେ ନା ଚିଫ ରେ କହିଲେ କ୍ରସ ରେ କହିଲେ ତାପରେ ମିଳାମିଶା ହେଇଗଲା କହିଲେ ସେ ଟୋଟାଲି ସେ ଜାଗାରେ ହିଁ ନଥିଲା ମିଳାମିଶା ହେଇନି ତ କଣ ହେଇଛି Alright, the learned counsel for the petitioner submit that the appellant is in judicial custody since 13 July 2021 and he has been charge sheeted under section A अच्छी से जो आगो bail order जो rejection order annex है earlier when the petitioner approached this court for bail in CRLA number 739 of 2021 taking into account the evidence of PW3, the eyewitness, in which he has implicated the appellant to have fired gunshot at the deceased. The bail application was rejected. The learned counsel for the petitioner submits that PW3 was recalled on the petition filed by the learned defense counsel and during his further cross-examination he has stated that when he reached at the spot he found his deceased uncle was lying on the ground sustaining bleeding injuries and many persons were present at the spot. And he further stated that he had not seen any of the accused persons at the spot and he had not seen the appellant at the spot. Learned counsel submits that since in the further cross-examination PW3 has given a complete go-by to his earlier deposition made in his examination in chief as well as in cross-examination. Taking into account the period of detention, the bail application may be favorably considered. Learned counsel for the state, on the other hand, opposed the prayer for bail and submitted that the petitioner was an absconder. Considering the submission made by the learned counsel for the informant has no serious objection for grant of bail to the appellant. Considering the submission made by the learned counsel for the respective parties, the respondent's development made the fact that the eyewitness PW3 has changed his version in the further cross-examination and stated that the appellant was not present at the time of occurrence. I'm inclined to reconsider the prayer for bail and direct the appellant to be released on bail, subject to condition that he shall appear before the London trial court on each date when the case would be posted for trial and shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail. Allowed.
Okay. I mean, pardon, CRLA, Nalad has told 739, it will be 620 of 2020.
620
of 20.
620 of 2022. Your aggo pratham application. It ଅଛି ଏଠି ଦେଖିଦେବେ ହେଲା.
ତଳେ ଅଛି.
Yes, next.
Obliged.
Item 22. Item 23.
May I please, Your Lordship?
26/12/2023.
What about notice?
Third on 30th January.
All right. This is item number 25. Is it the first bail application or earlier rejected?
My lord, anticipatory bail was there. No.
Okay. What is the date of custody?
Custody is, my lord, 26/12/2023. My lord, here.
Submitted.
Yes, my lord.
What are the offenses?
My lord, charge sheet submitted under offense 376, 417 of IPC. Then, my lord, section 31, 32V and VA of SC/ST Act. My lord, the petitioner and the informant.
What is the age of the victim?
My lord, 23 years. My lord, they were in the relationship since class 7.
64. ଦିଅନ୍ତୁ ନହେଲେ ପଢନ୍ତୁ ଯାହା କରୁଛନ୍ତି। Medical examination report कौन ହେଲା?
The medical examination report is in the charge sheet.
Hold କରିଛନ୍ତି?
On dated 2nd of September 2023.
देखिए आइए। What is your good name?
My lord, Shivani Samarpita Oja.
Okay, now लिखी ना। The Learned Council for the Excellent Learned Council for the State Learned Council for the State submit that notice and the informant has been made sufficient. None appears for the informant. Considering the submission made by the Land Council for the appellant that the appellant is in judicial custody since 26/12/2023 has been charge sheeted under section 376/417 of the Indian Penal 3132 VA of the SC/ST Act, and after going through the 164 CRPC statement of the victim aged about 23 years and the medical examination report which indicates that there was no bodily injury, no recent sign of sexual intercourse. I'm inclined to release the petitioner on appellant on bail subject to condition. He shall not try to keep in contact with the victim, shall not try to tamper with the evidence, appear before the trial court each date when the case will be posted for trial. Violation of any terms and conditions shall entail cancellation of bail. दरकार যদি অফেন্স নিয়ে তো লিখিবে নচেত আমি দিয়ে দেব। Yes, allowed.
Bless me.
Item 26.
Melody night of 26.
I am appearing for the informant. I got the notice.
Here the petitioner is in
You have
custody.
received the copy of the appeal memo? Okay.
Petitioner is in custody since 5th
Wait,
of
CD available?
Yes, Your Lordship.
Item 27, Mr. Pramod Kumar Swain files Bhinama for the informant, which is taken on record. Is it the first application or earlier rejected?
No, earlier it was rejected. In B
PRLA number 462.
462, yes, Your Lordship.
Ittu alias Murli Sahu.
He was granted also interim bail, and in compliance to that order, he was already surrendered on 27/3.
So the observation which has been made is that you are armed with a sword.
Yes, madam.
And you assaulted the deceased, and the deceased has sustained as many as 6 injuries on the vital part of the body, and the cause of death was on account of coma. And your bail application was rejected, and you are given liberty to renew the prayer for bail after examination of the eyewitnesses in the trial court.
Yes, Your Lordship.
And so what is the status of the case? What is the stage of trial?
Stage of trial, as of today, 3 witnesses all total has been examined out of 51 charge sheeted witnesses.
No. Question is whether the eyewitnesses have been examined or not.
Eyewitnesses 2 and 3, both are eyewitnesses. 2 was already examined that earlier, while considering Your Lordship earlier bail application, 2 evidence was there. Only 1 eyewitness was left. His name is
ସେଗୁଡା କିଛି ପ୍ଲେସ୍ ହେଇ ନଥିଲା ଗତ ଥର. As per the eyewitness account, eyewitness account means he perhaps placed the that statement 161 statement he placed. କାରଣ ଆଦିରେ କିଛି ଲେଖା ହେଇନି କୌଣସି ୱିଟନେସ୍ examine ହେଇଛନ୍ତି ବା ମୁଁ consider କରିଥିଲି witness. So whatever it may be. Now
I do have the certified
all
copy.
right. 3 witnesses have been examined.
Out of
all the 3 are eyewitnesses.
2 are eyewitnesses. 2 and 3.
PW2
rejection order, Lordship. Page 18.
Page
18.
18. Yes.
PW second para, 5th line, Lordship. PW2 and PW2 is the injured eyewitness, and the Mukesh Mandal PW3. Both are eyewitness. Now he has served copy matter. Nonetheless, Lordship, he has 4 criminal antecedents.
By the way, those eyewitnesses have implicated him.
Just now he has served.
All right. You go through it and you file that comprehensive affidavit because 4 criminal antecedents.
Yes. I'm filing that.
Give a copy to the so also to the learned counsel for the informant. The learned counsel for the appellant handed over the deposition copies of Ketra witnesses of the 3 witnesses to the learned counsel for the state in court today. Who submitted on verification of the case record that there are as many as 4 criminal antecedents against the appellant. Learned counsel for the appellant files the comprehensive affidavit relating to the status of those 4 cases, giving copy to the learned counsel for the state as well as learned counsel for the informant. Put up this matter next week as prayed for.
1 week after.
अच्छा, 19th of February 2020.
ସେ ଯୋଉ ଅରିଜିନାଲ ସାର୍ଟିଫିକେଟ କପିଟା ଦେଇଛି ଜେରକ୍ସ ମୁଁ ରଖିପାରିନି ଦେଇଦେବି ସାଙ୍ଗେ ସାଙ୍ଗେ ଜେରକ୍ସ କରିକି ଦେଇଦେବି
ସିଲ୍ ମାରିଦେଲଣି? ସିଲ୍ ମାରିଦେଲଣି?
I am collecting another copy from my learned friend. I will get it. The evidence copy ମୁଁ ଜେରକ୍ସ କରିକି ଦେଇଦେବି.
Item 28.
Yes, Mr. Das.
In this case,
Yes, it is.
All right, Land Council for the state submits that notice on the informant is sufficient and he has also received the CD. The Land Council for the appellant seeks for an adjournment.
Item 31.
May I please, Your Lordship?
Yeah.
Lordship, this is a Belgium matter, Lordship. In this case, the accused petitioner is forwarded on strength of NBW on 19/1/2024, and NBW was issued against the present petitioner on dated 3/11/2023.
Is it one of the offenses 3 SC/ST Act or what?
3 SC/ST Act.
So notice has to go. You serve an extra copy, send it to the AG office by the you'll be assisted by the system assistant, and
I have sent it
it
already.
can be, or you send it that copy to the okay. Since one of the offenses under 3 SC/ST Act, Land Council for the state shall send a copy to the inspector in charge of which police station it is?
It is the
Dhanupali police station for its service on the informant. Put up this matter in the week commencing from 19th February 2024. Heard Mr. D.P. Mishra Current counsel appearing through virtual High Court, Sambalpur. Yes.
Item 32.
We'll consider today, let the payment has been made, we'll consider this matter on merit where you, yes.
Item 33.
Yes,
There are 3 appeals. I am in criminal appeal number 657 of 2016.
you are moving all the 3 appeals or one?
ନାଇଁ ନାଇଁ ମୁଁ ଗୋଟେ appeal ସେଟା
Which one?
ତିନିଟା ଯାକ ସମାନ ଆଜ୍ଞା.
No, no, you are moving in which one?
657 of 2016.
657. What is the offense here?
376D, 306,
Yes.
363, 6 POCSO Act, conviction, and the sentence is 20 years.
Earlier bail application was rejected.
Nine.
So you have supplied deposition copies.
Last occasion,
Only thing you are also able to consider, my lord, they are inside custody since my lord 22/6/2013.
And last occasion, your lordship has directed the council for the state.
Custody certificate and CA.
कौन हला
No CA and custody certificate.
केते वर्ष हो
दे दे
देखी
up to 16/12/2023 my lord, it is 10 years 5 months 10 years 6 months
एटा कौन लिखछन्ती आपनकर अरुण सेठी
I am Madam Arun Sethi.
CRL 19 of 2000
अरुण सेठी रो केते वर्ष होची
से समान तीन जंग समान अछि 10 years
समान
18/6/13 arrested.
10 years 5 months 27 days
up to 16/12/2020
हाँ तो आउ किछि दिन अधिक हो एटा होची आपनकर 16/12/2023 ମାନେ ଆଉ ଗୋଟେ ମାସ କେତେ ଦିନ ଅଧିକ କୌଣସି କାହାର ବି ସିଏ ନାହିଁ
ତିନିଟା ଏକ ଦେଇଦେଇଛି
टेक डाउन फास्टर लिखंतु CRLA number item 33 CRLA number 19 of 2017 IA number 1899 of 23 this is an application for bail the Land Council for the petitioner submit that the petitioner has already undergone half of the substantive sentence imposed by the Land Trial Court and paper book has not been prepared there is no chance of early hearing and the petitioner is having no criminal antecedent, therefore the bail application may be favorably considered. Land Council for the state has produced written instruction received from IAC, Gosani Waga Police Station dated 19/1/2024 to the effect that there is no criminal antecedent against the petitioner. He has also produced the custody certificate from the Senior Superintendent Circle Jail Berhampur, which is dated 16/12/2023, from which it reveals that the petitioner is in judicial custody in connection with this case for 10 years, 5 months, 27 days. Considering the submission made by the Land Council for the respective parties, sentence imposed by the Land and Trial Court period already undergone by the petitioner in judicial custody, absence of any chance of early hearing, and absence of any criminal antecedent, I am inclined to release the petitioner on bail, stay realization of fine. Now you come to the second one. Bail application has been filed. Tadere Tanata Hochi 657. A period saman same order dekhi likh debe allowed kar debe bail allowed. Now 3 Hochi IN numbers 1 so एटा कोन दीटा बेल फाइल करछन ना कोन फाइल करछन मिस्टर दास
My lords,
थर्ड टारे
CRL 19
45
ना गोटे
45
condonation of delay थिला my lords.
45 रे देखि 45 रे कोन अछि से 127 टा कोन
1897 टा होची bail my lord.
हां
Miss IN number 1897 that is the bail application.
no that is a bail and 1898 होची
Stay relation fine.
स्टे रहते 127 टा कोन
127
दीटा सेटा भी स्टे रिलेशन ऑफ फाइन एटा को नॉट फेस कर दियंतु मिस केस नंबर 127 नॉट फेस हला बाकी से टाइप रो करी बेल अलाउ कर दियंतु आ स्टे रिलेशन ऑफ फाइन है ना एटा तीन जण करो डाटा टा आसी रखि जन
CRL 19 गोटे अछि CRL 19
आसिनी
अच्छा
फर्स्ट टाइम नोट आगे डाकिले पूरा
19 पूरा प्रथम डाकी
आगे
ठीक है नेक्स्ट
oblige my lords.
एटा नियन देखो तीन टा का लागिना नंबर उडा ऊपर लिखा है
Item 34.
May I please be for? My lord, last occasion, my lord directed to custody certificate produced to the state council. In the meantime, 50% more than 50%, 6 years custody out of 10 years.
What is the conviction and what is the sentence?
Sentence 10 years and fine 15,000.
Offense.
Offense 376. 2I and 6 poso.
10 years ରୁ କେତେ ବର୍ଷ ଗଲାଣି?
7 years 3 months.
ଦେଖି ଆଗୁ ରିଜେକ୍ଟ ହେଇଥିଲା ମେରିଟ?
No, my lord. Interim bail ରେ ଯାଇଥିଲୁ ଆମେ surrender କରିଛୁ କଲା ପରେ IA 3030 of 23 ଟା
the Land and Council for the petition, Land Council for the state, considering the submission made by the Land Council for the petitioner, that out of 10 years of substantive sentence imposed by the Land and Trial Court, the petitioner has already undergone more than 7 years of sentence. And after availing the interim bail period, he surrendered at right time. And after going through the custody certificate issued by Senior Superintendent Circle Jail, Baripada, produced by the Land Council for the state, which is dated 13/1/2024, wherein it is mentioned that the petitioner has undergone 7 years, 2 months, and 28 days of sentence. Absent of any chance of early hearing, I am inclined to release the petitioner on bail allowed.
$35.
Lordship, 35. I'm appealing for the appellant number 2, Lordship. Here I am the in custody since 15/9/2017, Lordships.
What is the sentence imposed?
Sentence is 10 years under section 20B2C.
देखिए judgment operative part.
Page 18.
Undergo RI for 10 years, fine of rupees 1 lakh. In default, undergo RI for 3 years. Okay. So it ଆପଣଙ୍କର ହଉଛି 6 years and 10, 11, 12, 1 5 ମାସ ହେଇନି ଯଦିଓ 5 ମାସ ପାଖାପାଖି ହେଲାଣି. Yes, Mr. 6 ବର୍ଷ 4 ମାସ କମ୍ପ୍ଲିଟ ହେଇଗଲାଣି. ତାପରେ ବେଲ ରେ ଥିଲେ
3 month bail ରେ ଥିଲି ତାପରେ
କେତେ ଥର ଯାଇଛନ୍ତି ବେଲ?
bail ରେ ଥିଲେ 25/3/2023 to 26/6/2023.
3 months ବେଲ ତ ଥରେ
ଥରେ
ଟ୍ରାଏଲ ବେଳେ ବେଲ ରେ ନଥିଲେ? ଏଲସିଆର ଟା କାଢିଲ. Accused produced in custody. କଣ ହେଲା?
ଲାଲୁ ମାଝୀ.
ବିଜୟ କଣ ଲେଖା ହେଇଛି? ଆପେଲ ନମ୍ବର 2 ହଉଛି ଲାଲୁ ମାଝୀର କଷ୍ଟଡି ହଉଛି 16/9. ଠିକ ଅଛି, 16/9 15 ଆରେଷ୍ଟ ହେଲା, 16/9 ପ୍ରଡ୍ୟୁସ ହେଲା କୋର୍ଟରେ. All right, heard the Land and Council for the petitioner, Land Council for the state, considering the submission made by the Land Council for the petitioner, that the petitioner is in judicial custody since 16/9/2017, and out of 10 years of substantive sentence imposed by the Land and Trial Court, he has already undergone sentence of 6 years and 4 months. No, 6 years 4 months केमती हो?
6 months, one.
More than 6 years कर दिया. And once he has been granted interim bail for a period of 3 months, and after availing the same, he surrendered at right time, and there is no chance of early hearing of the appeal in the near future. And keeping in view the ratio laid down by the Honorable Supreme Court in case of Muhammad Muslim, bail is allowed. Appellant number 2 right a bail hala. A2 released on bail. Yes, the na likhiye. Yes, next.
Item 36.
36.
Wait, please, my lord. Here, my lord has extended the protection to the petitioner appellate all the time. But as the unfortunate situation is that she is suffering from cancer, and your lordship directed her to be released on bail by depositing cash in every month, and she also deposited more than 50%, around 14 lakhs and more than that. Considering that and taking into account the fact that she is suffering from cancer, your lordship modified that order that let her give the property surety for the balance amount so that she can get herself treated because she was going to be operated. Then after your lordship passed the order, then she tried her best to furnish the security, but the security was not accepted there in the court below. The counsel said that there is some kind of insistence that anybody from her family should give the property surety, and that was almost impossible. So thereafter, what has happened? A warrant of arrest was issued. Again, she came to your lordship. Your lordship was very, very pleased to grant liberty that furnish fresh security. Then she went, gave the property surety of her father-in-law to some extent, as was possible, and the rest amount was from an outsider. Thereafter, the application was filed for recalling the warrant of arrest and accepting the security because she was there then in the treatment of the doctor at Bhubaneswar. This is the background, my lord. I do not know much about the intricacy, my lord, here involved in the situation, but your lordship gave the maximum protection to a lady who is suffering from cancer. And it was the absolute difficulty that she could not appear in person. And that is the only reason the learned court below said that since she is not appearing in person, it cannot be considered.
What do you want? The order was passed on 19/12/2023, the last order which was passed.
Yes, my lord.
That if the petitioner files fresh property surety, that will be taken into account in accordance with law.
That is your lordship's last order,
right.
my lord.
So whether you complied that order or not?
Yes, my lord. I filed the application security as well as an application that
was accepted.
That was not accepted because she was not able to remain present herself. That is the only ground.
Where is that order?
My lord, that I have annexed, my lord. Your lordship will find.
So now what application you are filing?
This is, my lord, IA number 112.
What is your prayer?
That is there. My prayer is limited, my lord, that to stay execution of the warrant. The other application is IA 111. I filed 2 applications. I do not know. I thought that 2 applications will be necessary. Then the other application is for appropriate order regarding acceptance of property security furnished by the father-in-law of the appellant and another person of the locality on.
No, that is satisfaction is up to that trial court. I
That
cannot
is
say.
I do concede.
I cannot compel somebody to accept. If they are the best person, they will verify.
My lord, exactly, my lord. That's the position your lordship. I need not say, my lord, about this. How your lordship will protect, my lord, for a lady?
Question is that when you are to satisfy the concerned court, they were not satisfied, so you are to file fresh.
I filed the fresh, but it was rejected only on the ground that she could not remain present.
Where is that order, particular?
My lord, that order your lordship will find. I have annexed it.
Yes.
Annexure 2, my lord, at page 12, IA 111. Your lordship. Has your lordship got it?
Yes, yes.
Then that page is page 14, my lord. I am placing, my lord, that order.
1/4.
Yes, my lord, 1/4.
You want to place 309, order number 309 or 310?
310, my lord.
Yeah.
The record is put up for hearing on petition dated 6/1/2024, filed on behalf of convict petitioner Satrupa Mahanti, whereunder petitioner has prayed to accept the property security and to recall the order dated 5/12/2023, passed by this court. Copy of the petition has been served on the learned APP, had learned counsel on behalf of both the parties. Learned counsel for the convict petitioner would submit that in view of direction of the Honorable High Court of Orissa, the present petition has been filed for acceptance of the property security and to recall the order dated 5/12/2023. Convict petitioner is absent. At this stage, learned counsel for convict petitioner submits that convict is not present in the court today. He further submits that convict is unable to come to the court to furnish the property security due to her illness. On the basis of the above submission, learned counsel for the convict prays that warrant issued against convict Satrupa Mahanti by order dated at may be recalled and the property security may be accepted on her behalf. Then will order the contention of the learned APP. Then your lordship, if your lordship sees the next para, peruse the material placed on record. It reveals that there is no such order dated 5/12/2023 for recall of which the convict has presented this petition. However, by the order number 306 dated 8/12/2023, as per direction of the Honorable High Court, by the order number 18 dated 5/9/2023, passed in IA number such and such, arising out of CRLA 537 of 2020, the bail order passed in favor of the convict.
In the operative portion, what you are telling, that is the thing that it is needless to say that although some documents have been filed purported to be the property security, but the petitioner herself is absent for verification of the identity and solvency. Accordingly, the petition was rejected and NBW has been NBW was earlier issued.
Earlier.
So
thereafter, your lordship permitted me, my lord.
This order is dated 8/1/24.
My lord.
Now you are to just present yourself with your sureties, and if the sureties are accepted, then there would be no problem.
No problem, with your lordship's
but
permission.
If your sureties are not accepted, then obviously you are to go inside.
My lord.
So tell me a date on which you, along with your surety, will present before the London trial court.
My lord, may fix up 5th Monday, any Monday. Lord.
IA number 112-111/2024. This application has been filed for acceptance of property security furnished by the father-in-law of the appellant and another person of the locality on 8/1/2024, and to recall the warrant of arrest issued by the Learned Chief Judicial Magistrate Mayurbhanj Baripada in GR case number 1239 of 2014.
By order 5/12/2023.
Order detail लिखिदेल तो 8/12/2023.
5/12 my lord.
8 बार लिखाई जी. अपन को prayer portion को आसंदु 111 रे.
My lord.
Is it a typographical error or it is page number 6 को आसंदु?
Yes, my lord. I have seen that. Probably it's but what I find from the order sheet at page 14, I read out. That is 5/12.
नहीं 8/12 तो लिखा है जी. 8/12 कोटा 8/12 हाँ 8/12 ठीक है जी.
8/12
and IA number 112 of 2024 has been filed by the petitioner to stay execution of non-bailable warrant of arrest issued under Annexure 1 as per order dated 8/12/2023 against her till acceptance of property security. From the order dated 8/12/2023, from the operative portion, the order dated 8/12/2023, it appears that କୋଉଠି ସେଟା ଲେଖା ହେଇଥିଲା ସେ ଯୋଉ ସେ appear କରି since he is not appearing କୋଉଠି ସେଟା
My lord, page 15.
15 ଆଚ୍ଛା from the order dated ଆଚ୍ଛା 8/1/2024 लिख है ना passed by the London trial court, it appears that though some documents were filed which are purported to be property security, but the petitioner was found absent for verification of her identity and solvency, the petition no order was passed and the prayer was not accepted and the petition filed by the petitioner was disposed of. Land counsel for the petitioner submits that the petitioner is ready and willing to appear before the London trial court on 12th February 2024 along with the surety and the sureties shall furnish property security.
They have furnished, my lord,
That
as your lordship directed.
whether you are to file the fresh one because ସେଟା ଆପଣଙ୍କର original ହେଇନଥିବ xerox copy ହେଇଥିବ.
No, original ଗୁଡାକ court ରେ ଦାଖଲ କରିଛନ୍ତି.
ଆଚ୍ଛା.
That is instruction.
It is stated that the property security papers are available in the before the London trial court. If that be so, on the appearance of the petitioner, the date fixed, the London trial court shall pass necessary order regarding acceptance of the property security after verifying the same in accordance with law. And till the next date, that is 12 February 2024, the non-bailable warrant of arrest issued against the petitioner is kept in abeyance. Both the interim applications are disposed of. Like either both they are taken together and disposed of by common order. Yes, no.
Obliged.
Item 37.
Please, your lordship. And appellant petitioner is custody more than 9 years. And conviction is, my lord, for petition and 376(2). I
comprehensive affidavit file
number टा पढ़ने के लिए अच्छी
It's all right. 133 of 2024 सेटा तो उची petition टा.
Again.
ଆଉ ଗୋଟେ separate affidavit ଦେଇଛ?
No, my lords. In that IA,
in
I have
that IA
annexed
you
the
have
bail orders also
so
of the tables of contents of the.
so Mr. Tripathi ସେ କଣ 20ଟା ଆପଣ ଦେଇଥିଲେ ସେ 14ଟାର ପାଇକିନି ଯାହା ଲେଖିଛନ୍ତି. ଦ୍ୱିତୀୟ କଥା ହଉଛି time to time he has been granted interim bail sometimes 2 weeks ତାର health condition ନେଇକିନି. So what instruction is available with you? Because he's a cancer patient.
Oral cancer
And
patient under chemo.
whether any accusation that he has misutilized the liberty or not, that you are to file. Apart from that, whether this statement which has been mentioned that bail has been allowed in different, whether that is
I
correct.
filed the copies of the bail order, and your lordship may kindly visualize one thing, my lords. None of the affairs he has been named. Every affair is against unknown
No,
person.
no. In that ଡକାୟତି case ରେ ନା କୋଉଟା ଆସିବ? ଏଟା ସବୁ ଗୁଡାକ most of the cases are either 380, 394 ଏଇଗୁଡାକ ସବୁ type ର. So Learning Council for the ଏଟା ଲେଖନ୍ତୁ IN number 133 of 2024. There is an application for bail. The Learning Council for the petitioner has mentioned the status of 14 cases instituted against the petitioner. And in paragraph number 4, he has mentioned for what period, in which interim application the petitioner has been granted interim bail. It is further mentioned that the petitioner is suffering from oral cancer. The Learned Council for the state seeks some time to obtain instruction on this interim application, more specifically whether the petitioner has misutilized his liberty in any manner while on interim bail or not. Put up this matter in the week commencing from 19th February 2020.
Let's may respectfully pray one more thing. Since your lordship is calling, a report may also be called for as per the health condition. He is
He is
suffering,
now
my
in
lords.
which jail?
That's at Nimapara jail, my lords.
It is stated that the petitioner is lodged in Nimapada jail. Let a land council for the state obtain a health condition report of the petitioner from the concerned jail superintendent. Yes.
Grateful, my lords. Lords, may I pray next week in view of the.
Yes, sir.
Grateful,
Next,
my lords.
item 40.
Item 40.
Mr. Jena, not there.
May I please, your lords?
Yes.
My lord, in this case, my lord, the appellant convicted 12 years, my lord. But a minimum sentence is, my lord, 10 years. The factors.
My senior got held up in court number 1, Lordship, for Passover.
What is the conviction and what is 12 years you have been
Convicted.
but what is the offense here? Oh, 20B2 C.
20B2C.
So how much you have already undergone?
5 years or 2 months. 2 months or 12 days. My case is not coming under 32B, my lord. So if sentence will be 10 years minimum punishment, 10 years, then I have already in custody 5 years.
Senior is not there, he is telling. So we'll take up this matter tomorrow. Ask your seniors to remain present. Because today there is paucity of time. Yes. Yes, next.
Item 42.
May I please, Your Lord? In this case, your
stay realization of fine to be considered after receipt of the trial court order. Okay. Yes, which matter, Mr. Jena, you are mentioning?
But 47, my lord, your lordship are directed to serve the deposition copy. I have already served. And
the matter has been admitted, or?
yes, your lordship.
Yes, yes, admitted. What is the conviction and what is the sentence here?
My lord, the conviction is under 363, 366, 376 2L IPC and with 6 of the Postal Act. My conviction is
You have received the deposition copy.
Yes.
We'll take up this matter tomorrow. It will come tomorrow. It will be taken up tomorrow. Okay.
T6.
Kali?
पढ़ू नहीं आएगा लास्ट लास्ट
Top of the list আসলে
Top of list
rest of